Good morning.
For today.
Thank you.
Morning, Judge Wilson.
Yes, sir.
This is Kenny from the DA's office.
Yes.
I just wanted to step in and just let you know we were myself and Mr. Carroll were speaking about one of the expunctions that's set on the docket for today.
Okay.
Devin Williams. The state has no objection and is going to stay silent in this situation.
All right. Thanks.
All right, Judge. Do you need anything else from me?
Nothing I know of. No.
Okay. Thank you, Judge. Jumping over to the other docket. Thank you.
Thanks, Kenny.
No problem.
All right, ladies and gentlemen, I have about 9 o'clock. I'm going to call the dockets. I'll ask for announcements from the attorneys. Anyone who's present who doesn't have an attorney or your attorney doesn't answer, make sure that I know that you're here. Otherwise, please keep your electronic devices muted. Start in alphabetical order. Atascosa County, SEMA Resources versus H.A. Stowe.
Good morning, Your Honor. Megan Harkins here for the heirs. Judge, that is a determination of heirship matter. That is uncontested. We are ready to proceed. Grace Pereira is the ad litem and Trent Rowell is our witness. I'm scrolling through to look for them.
Ms. Pereira just signed on.
Yes,
Trent
there
Rowell
she
is
is.
signing on right now.
Okay, Judge, so whenever you're ready, we're ready.
Okay, how long to hear this?
Judge, I would say about 15 minutes max.
All right, I'll mark you 15 minutes.
Thank you.
Rendon and Ibarra versus Deanna Skinner.
Yes, Judge, this is Barrett Ship on behalf of Ship Ecky. That's a motion to withdraw our motion. It's about 5 minutes. I believe Zachary Edwards is also on the call. It's unopposed.
Okay, is Joe Rendon or Julian Ibarra
Well,
here?
We'll have to ask for them to be called, Your Honor. I'm not see, that's only a withdrawal as to Julian Ibarra.
Oh, okay. All right. And you have, you notified Mr. Ibarra?
We have good service, yes, Your Honor.
Okay, I'm gonna mark you just X. What I'm gonna ask is go ahead and post to me in chat a copy of your proposed order. And you can free to check out as long as the coordinator's office has your contact information, especially with Zoom and people who are pro se. I want to wait till about 9:30 because I've granted too many things and then people come wandering in. But if nobody appears by 9:30, I will grant it.
Yes, Your Honor, we will do that.
Thank you. All right, matter of the marriage of Rebecca and Marco Mendez.
Yes, I'm here.
All right, man, are you ready to proceed?
Yes, Judge.
Okay, I'm going to mute you. I'm not sure what's going on. Every time you've been unmuted, we're getting some kind of electronic feedback. But I will mark you A. You will be the first self-represented case I call up. All right, and Ms. Riley, I'm going to make you the host. I'll ask you to make me the co-host. I'll find you. Well. She was here a moment ago. I'll wait for a moment.
I'm here, Judge.
Oh, there you
You're
go.
looking for
Okay, I'm
me?
going to make you the host.
Yes, sir.
Ex parte Devin Williams.
Yes, Your Honor. John Carroll here on behalf of Devin Williams, and Mr. Williams is present as well. It's a petition for expunction, and as Mr. Lamb of the District Attorney's Office stated before the docket call, there's no opposition.
Okay. All right. And Ms. Carroll, if you want to just post that to me in chat. And do you have a service on everyone?
Yes, Your Honor.
Okay. If you'll just post that to me in chat, I will sign it.
We'll do that.
Ex parte Corey McCluskey. Corey McCluskey, this is another expunction.
Can you hear me?
Yes.
Yes, I'm present. Pro se, representing myself.
All right. And are you ready to proceed?
I believe so.
All right. I'll mark you B. And you'll be the second self-represented case I call up. Karnes County, in the interest of Tiana and Michael Drum.
Your Honor, we're actually dropping that. An attorney, Krista Branch, appeared on the case yesterday afternoon. And she pointed out that the case actually should be in Wilson County. It's false. It's like right on the line of Fall City. So we do have an agreed order to transfer to Wilson County. If I could submit that on chat.
Absolutely.
Okay, thank you.
I guess it's not like a, what on criminal cases, if it's within 200 yards of the border, you can file it either one, but you don't get that.
No.
Okay. Yes, if you'll put that in chat. Give me just a moment. All right, Wilson County docket. 18-1-13 in the interest of the Leal children. Mr. Nichols, I believe I saw.
Yes, Judge, you can pass that. Miss Tapia is not available today, and we're going to worry about it later.
All right, reset on request.
Please. I know you were excited to hear that again.
Okay. Mendez versus Guadalupe Valley.
That case has been dropped, Judge, and reset to May the 5th.
Excellent. Matter of the marriage of James and Mary Jo Riley.
Good morning, Your Honor. We're here on a motion for enforcement and a motion to compel. If we need a hearing, I think it would probably take about 30 minutes.
Your Honor, Frank Gonzalez on behalf of Mr. Riley. Judge, I don't know that I have authority to act at this point. We have a pending motion for withdrawal set on the 5th of May. If Mr. Riley is present, then perhaps I can speak with him regarding today's motions. But otherwise, Judge, I would announce not ready and ask that all of these be consolidated with the hearing on the 5th.
Okay, is Mr. Riley here? I don't hear.
I didn't see him, Judge. He's not been in communication with my office since I guess in probably a couple of weeks when we got notice of this, and thus my pending motion.
Okay. All right, I will mark you conferring for the time being.
Very well, Judge. Your Honor, if I may be excused briefly to answer the 9 o'clock docket in Bexar County, I'll leave them after I announce and come back and join the court with the judge's permission.
That's fine.
Thank you, Judge. Ms. Nettles, I'll be right back. Thank you.
Thank you.
All right. Matter of the marriage of Merlin and Kimberly Palashik.
Your Honor, we have an MSA on that. We're just going ahead and getting signatures. So we have moved that over, I believe, to the 14th by Rule 11 agreement. So reset.
It was reset to May the 10th, actually, by that Rule 11.
Thank you, Ms. Riley. I
Right,
apologize.
Okay. And you expect it will be resolved?
Yes, Your Honor. I think it'll just be for entry.
Okay. Does he still have the barber shop?
I think it was his dad's barbershop.
Oh, he was junior. Okay. Okay.
Yes.
All right. I was going to say I haven't gotten my hair cut there in a while, but I'd hate to irritate the person that has sharp instruments around my head. In the interest of Carson Foster, a child.
Judge, I am here on that as well. We are here on temporary orders. We're ready. I think we'll probably need about 45 minutes, 45 minutes.
That's correct, Your Honor. And we'll confer. You want to confer, Mr. Nichols?
If you'd like.
Please do so. And Mr. Cedillos, there's a Corey Calvano on. Are you the attorney? Are you with that attorney? Is that an old?
Well, I'm represent the respondent, and that's the AG's office.
Oh, okay. That's AG. Okay. All right. So I'll just put down here to add you because it has, so who's the petitioner? The AG originally?
Originally, yes.
Okay. All right. So I'll put third party Andres Cedillos. Okay. I'll ask you to confer.
Can we get a breakout room, Judge?
Ms. Riley is the host. She is in charge of those.
Thank you.
Although actually I'm the co-host this morning. And for those of you keeping score at home, I have access to breakout rooms as co-host. About half the time I do and about half the time I don't.
I have one other.
And I can
one other
find
announcement, Your
no
Honor.
rhyme or reason why that happens. Okay, in the interest of the Yawi children,
Your Honor, that's also mine. That's gonna be a name change. I've got to locate my client. It'll be about 10 minutes. It's just a name change for 3 children,
okay,
but I have to contact my client.
all right. And Wilson County add-on, in the interest of, it's 15-137, in the interest of AC Brighton, a child.
Yes, good
Okay.
morning, Your Honor. Jody Head Lopez. I'm here for the father, Michael Brighton. We have a motion for temporary orders before you today, and we have a motion for you to confer with the child in chambers today. Since I filed my motion, Carolyn Hewlett has filed an answer, and she's also filed a motion to transfer. The mother of the child moved right on the edge, still in Livonia, but in Guadalupe County. So they do have a transfer to Guadalupe County. However, the code does allow you to make temporary orders to be placed in effect until we can do all the paperwork to get us over there. And the child would like to speak to you. The school this morning has said that one of the parents would have to check her out to bring her to the courthouse to go into the Zoom room. So I would just ask the court for housekeeping matters this morning to see which of the parents you would allow to go get the child so that you could confer with the child. She is she was born in 05, so at this time she's 15, Your Honor.
All right. Does she have a cell phone? Can she appear?
Your Honor, this is Caroline Hewlett for the respondent, and I was under the impression we were going to announce conferring, but we will need additional time, so I'll also announce not ready if Ms. Lopez isn't willing to confer.
Okay, well, I'm going to direct you to confer, and even if we do wind up having to have a hearing this morning, I'd also ask if it's not possible to, unless the parties are without access to a smartphone or a computer, I don't see any reason to withdraw the child from school in Livonia and have her driven all the way to the Zoom room here in Floresville.
Your Honor, I believe that the counselors at the school did not want to allow her to come into the counselor room. They did not want to take responsibility. However, I would be fine with either parent driving to the school while Ms. Hewlett and I are conferring, and they could then sit with the child, give the child their cell phone. They could excuse themselves while you spoke to the child. That way she's only checked out of school for the time you're talking to her, and then the parent could put her right back in. And I do not have a problem with whichever parent goes over there, Your Honor.
Okay, I'll ask you all to discuss that as you can, when you're conferring in your breakout room.
Okay, thank you, Your Honor.
All right, if you can't resolve it, I'll make a decision. All right, anyone else told to be here today, your case was not called? I see several people I haven't heard from, I think. There's an iPhone that says Phil, I believe.
Judge, they're here on my case.
Oh, okay. All right, so anyone else? Your case wasn't called? No? All right, I'm going to ask Ms. Riley to open up the breakout rooms, and she just did. We will begin with the SEMA Resources versus H.A. Stowe.
I'm ready, Your Honor.
All right, now I see a bunch of other attorneys here. Ms. Vickers, Mr. Dotson, do they need to be present?
Not for my case, Judge.
Okay.
That was a prior matter.
Oh, Judge, I know what you're saying now. No, Judge, that was for the receivership, and I can give you a little bit of background just to refresh.
Okay.
May I proceed?
Yes, sir. Go ahead. Yes, ma'am.
No, that's okay, Judge. Okay, Judge, this started as a receivership, and this, back from 2011. Judge Hurley, you appointed Judge Hurley as the receiver. He's aware that we're proceeding on this today. We just need the court to declare who the heirs are. So we'd like to put on proof of that today so that the receivership can be concluded soon. So that's our goal today.
Okay, and was Mr. Rao on this one also?
I'm
Judge, he's
here.
here.
Go ahead.
No, Trent, you can go ahead.
I got involved in this because Judge Hurley was the receiver and was approached by the heirs and landmen and such. And so Judge Hurley can't be here today, but I'm just here if the court has any questions. And I have had reviewed some of the airship stuff as well. So I'm just here as an observer or a witness or whatever anyone needs me to be.
All right. Okay, give me just a moment. I'm trying to log on. This is my old backup personal laptop because my state computer is down. Okay, I think I'm going to be able to do this. All right, go ahead, ma'am.
Thank you, Your Honor. Just a little bit more background information, Judge. The decedent in this case died in 1919. We'll put on evidence today of all the work the family has done to determine who the heirs are, but we do not have any disinterested witnesses besides Mr. Rowell, who's been involved from the start. So at this time, I'll proceed and call my client, Ronald J. Munns.
Okay. All right, would you raise your right hand, sir?
Yes, sir.
Do you solemnly swear or affirm that the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and go ahead, ma'am.
Thank you, Your Honor. Are you Ronald J. Munns?
Yes.
And are you an heir of Herman Augustus Stowe?
Yes.
And did you intervene in the receivership action to ask the court to determine who the heirs are of Herman Stowe?
Yes, I did.
And at this time, do you agree with me that a citation ran in the newspaper for any unknown heirs?
Yes.
And Judge, I ask that you take judicial notice of that citation in the court's file.
Okay. I'm going to let you put your evidence on. I'm not able right now. I'm going to try it on my other computer and see if I make it work. I was able to get into the clerk's records and pull up the case, but whenever I hit the view button, it gives me an error message and I'm not able to actually look at any documents. So I'll take judicial notice of the entire contents of the file, but I'm not going to finalize this until I can actually look at the documents. So give me just a, go ahead, and I'm going to try and get this on my other computer.
Okay.
Go ahead.
Thank you. Okay, Mr. Munns, did you and your sister Susan Parker kind of spearhead this heirship proceeding and get all of the research done for this case?
Yes.
Let's talk about what. Yes, and she's on as well today listening, right?
Yes.
Okay, let's talk about what all you discovered. Did you provide several binders of documentation to the attorney ad litem containing all of the evidence that you and your sister, with the help of a landman, uncovered?
Yes, many binders, many family trees, family Bibles, family reunions for the last 73 years.
And do you recall how many heirs there are in this case?
26, I think.
And do you personally know a majority of those heirs?
I think I know every one of them.
Now, are there also 4 heirs who are named that are on one side of the family tree where it's not quite clear who the actual heirs are at this time?
Correct. They were nieces and nephews of great uncle Charlie.
And is it your position to the court that you expect that those shares will stay in the registry of the court in case they are claimed?
That's correct. That's my
And
understanding.
for all of the other heirs who are named, did you obtain waivers and consent to this heirship in this case?
Yes, 100%.
And did you also provide to the attorney ad litem death certificates, wills, deeds of transfer, estate filings, historical photos, and other genealogical evidence of the family history?
Yes, we did.
Genealogical evidence?
I'm sorry?
Genealogical evidence?
Yes, yes, Your Honor.
Go ahead.
And are you confident that you and your sister, with the help of a landman, uncovered who all of the heirs are in this case?
Yes, very confident.
And did you do any online research, looking around just to make sure you didn't miss anyone? You or your sister or the landman?
Probably, since we actually knew all of them, I even met great uncle Charlie before he died, and the great aunts, Aunt Eileen and my great grandfather and stuff like that. I met all of them, so I didn't need to go online.
Okay. Now, is there, let's tell the court, what is the reason that this determination of heirship needs to occur?
Well, the purpose is to determine heirship. There's a receivership involved. We want to establish proper heirship for the land and the oil rights associated with it.
And once we're able to do that and the receiver can distribute the funds, can the receivership be closed?
Well, I think there's 4 outstanding people that'll still stay in there.
Yes. So I guess to all the other heirs, can the receivership stop working for them? Okay. Judge, I'll pass the witness.
Mr. Rowell.
Judge, I have no questions.
All right. What other witnesses or evidence, Ms. Harkins?
Judge, that's really all we have, but I know that Grace Barrera, as the attorney ad
Oh,
litem,
I'm sorry, and I'm looking back and forth. I just see where she filed her answer, and I should have called on her and not Mr. Barrera. Okay, Ms. Barrera.
I don't have any questions, but I was going to ask Judge, do you want me to post my report on the chat for you to view? It got accepted this morning.
Let me see if I can pull it up on my state computer. The answer yesterday was no, but I can pull up the citation. Let me look at the. All right, no, I am able to pull up your report. Go ahead, ma'am.
Okay, I have no questions, Your Honor, for Mr. Wils.
Okay, and let me ask, what percentage of the 100% owned by the decedent or decedents, husband and wife, it looks like, has been found?
That would be, correct me if I'm wrong, I don't have the numbers in front of me, Megan, but I think it's 88%. Roughly, there's 12% that is going to be left in the receivership.
Yes, that's exactly right.
Yeah, there's 4 people who they found their names, but were not able to get a hold of them to sign waivers for citation or serve them. So they did the publication, but their names are identified, but their location is not identified.
Okay, and I take it that they're all the heirs of one child or grandchild of the Stowe couple that we're dealing with here?
Yes, they're.
Uncle Charlie was married to Aunt Esther, and there was an agreement that Uncle Charlie's four nieces and nephews would get whatever, would have gotten that 12%. And so we
Judge,
don't know where they are.
It wasn't a will that gave them that percentage.
Yes, Your Honor. Oh, I'm sorry, Grace, go ahead.
I don't know if they have like a chart of the family tree. If you want me to post that to you, Judge, that might help explain what generation we're at.
Yes, and do you have a proposed order also?
Yes, Megan has that.
Yes, I do, Judge. And I'm on a tablet because I'm on Judge Ellison's court on my other laptop. So I cannot, it will not allow me to upload the proposed order to the chat. Grace, I don't know if I email it to you, if you can do it, or Judge,
yes, I can do
okay.
it.
I'm sorry, I'm not used to having to be on both devices. So
That sounds confusing to me. You can email it also, Ms. Harkins, so I can get it.
oh yes, Your Honor, I will go ahead and do that now.
I believe we're at a fourth, fifth generation heirs and what they're going to be, who's going to be receiving. And the chart should show that, help you out a little bit, Judge.
Yes, what we're dealing with is Herman Stowe and Mary Corson. Their daughter Esther Stowe and her husband had no children, but she did have a will that was probated and left her estate to these heirs. So that's what we're dealing with here.
Okay.
And it was interesting, Judge, in regards to some of the stuff they had. Their family did a big family reunion since generations ago, and the newspaper articles would pick it up every year because they would rent out a whole park. So there's like pictures of the family throughout the years of every family reunion. So they had pretty good documentation from generations ago of that.
That's good. I can remember my family did that, but not, there was one that I was out of the country when they had it. Apart from that, they haven't done that since I was a little bitty kid. Okay. And is the Carnes District Clerk's office online?
They were for my case, Judge, but they may have gotten off because that was the only Carnes case.
No, they are. I see them.
They're on, Judge,
Okay.
but they may have stepped away from their desk.
All right. So I'm going to upload the order transferring to the Carnes District Clerk, and I will go ahead and send a copy of that. No, I won't. But let me just. Okay, and I'll check my email in just a moment for that proposed order. Okay, and that hasn't arrived yet. But
I just sent it, Judge. It was loading slowly. As usual, the technical difficulties happen during the hearing.
of course. Here we are. Now, do we need to have an order severing out the heirship interests of this part of the heirs. So if this is a final order,
Judge, we can do that.
I mean, don't do it for me, but I'm not sure that it's final. So you might consider that and see what the landman wants. I mean, if the oil company is happy with this and they'll distribute the proceeds, that's great.
Judge, we'll check on it. I guess, yes, I can check on that today and see if they'll accept this.
And I think Y through A, B are the heirs that don't have the waivers.
Yes, that's correct.
Yes, and I would want to actually, I'm going to ask you to go ahead and get an order that severs out everything that we don't have the waivers on. So the rest of it will be final. I don't know, but I don't think I have jurisdiction to, well, but.
Yes, Your Honor.
These people, they could be dead. They could have died or they could have sold their interests.
I agree, Judge.
They don't know that they're there, but yeah, so I'm going to ask, let's go ahead and get an order severing out their interest. That way, if they ever show back up, all they need to do is just get an order signed. If they agree that that's what they own and none of them have died or conveyed away their interest, they can just get an order signed, finalizing that, and they won't have to do anything else. Okay, but I will go ahead and sign this right now.
Thank you, Judge.
And
Yes,
post that to Atascosa County. Is Atascosa County on?
I don't think they're on, Judge.
All right, I will e-file this then. All right, I will go ahead and e-file this in just a moment.
Thank you, Your Honor. May we all be excused?
Absolutely.
Thank you.
Thank you, Your Honor.
Judge, have a good day.
McCluskey 2013. All right, Mr. McCluskey, I'm going to call up your case and look at that on the clerk's records. All right, Mr. McCluskey, do you have your proposed order? And you're muted, sir.
Yes, I do.
Okay. Have you given a copy of it to the district clerk or?
It should have been e-filed.
Judge, it is in the e-file queue.
All right. Go and look at that.
I'm gonna forward it to your queue, Judge. It looks like it's in the court coordinator's queue, so let me get that to you.
All right, sir, I've got your proposed order. I will sign this and send it on to the district clerk's office.
Thank you.
Actually, I'm going to send it to the coordinator's office first so they can close the case out, but then they will do that and send it on to the clerk's office. So that should be there later today. And you are excused. Have a good day.
All right, thank you.
Your Honor, on that motion to withdraw,
Yes, nobody's
you asked
here.
us to come back about 9:30, but I'll defer to you. It's your.
That's great. Have you sent me the proposed order?
It's in the chat, Your Honor. We just asked for Julian Ibarra to be called in the hallway and then hearing
Well,
nothing.
We have no one on from the Gaddis County. All right, I don't actually see anything from you in chat. Oh, okay. And I say that and I swear I just looked and it wasn't there. All right.
Mr. Edwards, what's an email for you? I can forward this to you if I see it.
You can send it to Z Edwards at Atomy Law. That's ADAMILAW.com.
That order for withdrawal is also in your queue, Judge.
All right, well, I've already signed it. I will e-file this.
Thank you, Judge. May we be excused?
Yes, sir. And I just sent that to Mr. Edwards and to Mr. Ship, I think. No, it keeps sending it to Edwards. Having trouble. Barrett, Ship, you're right next to each other.
We'll circulate it. Thank you, Judge.
All right, you're welcome. And I will get this e-filed.
Thank you, Your Honor.
All right, and I see Mr. Gonzalez. Are any of the attorneys have anything ready to go?
Yes, Your Honor, I'm back. My clients are not present, but I'm ready.
Yes, Your Honor. I'm ready on this, Your Honor.
Okay, and how long to hear this, Ms. Nettles?
Your Honor, it should take maybe 15 minutes or less.
All right, go ahead.
Your Honor, for the first one, we're here on a motion for enforcement. We're simply asking for a clarification. There was no date put for the appraisal to be paid by. The appraisal was already done by Menon Associates. We're only asking for clarification on that temporary order to say that it is to be paid by May 30th. That way it's paid before the final order, and that would take care of the first issue.
Uh,
All right, and Mr. Gonzalez, were you able to get in touch with your client?
I've not been able to do so, Judge. He's not responded. I can say, Judge, I don't have the authority, obviously, to make agreements, but I don't believe that what Ms. Nettles is asking for is unreasonable.
Yeah, I understand your position. All right, I will grant the relief asked for in that issue. And on the next one?
Your Honor, on the next one is a motion to compel discovery. That discovery was due on December 10th of 2020. The parties agreed to an extension on December 22nd, 2020. On that day, I received an email stating that it was mostly objections, but it would probably be coming supplementing at the beginning of the holiday once the holidays were done. I waited the 30 days till January 22nd, 21, and I still didn't receive anything. I sent over a discovery dispute letter. I sent over another letter on March 12th to inform them that I did not receive the discovery. Then on March 31st, I asked for the discovery. Mr. Gonzalez stated that he had probably missed that letter. And I resent that on April 1st. And then to date, I haven't received anything as to that. I'm just simply requesting that I'm not asking for anything else, simply for him to answer the discovery, the numbers that I had requested. That is, let me look at it. Those were for, I'm trying to pull up my order. For production, for interrogatories, it would be numbers 2, 3, 4, 7, 10, 13, 14, 15, 17, 18, 19, 20, 21, 22, 23, 24, and 25. And for my requests for production, it was 2, 3, 4, 5, 6, 7, 8, 9, 14, 16, 17, 18, 19, 20, 21, 22, 24, 29, 30, 31, and 32.
Okay. And Mr. Gonzalez?
Again, Your Honor, Ms. Nettles is correct with regards to the sequence of events that have occurred. I believe that we had extensions going back both ways on our discovery, but I did miss the March 31st letter, as she indicated. We were in trial and missed it. I have attempted to communicate again with my client, Judge. I have just not received any Well, I initially received a response, but I have not received any documents nor any affirmation of when I might receive those documents. So again, Judge, I'm kind of limited in what I can argue before the court. I would say, Judge, that again, I don't know that my client has attempted to avoid this. I do know that he's on the road a lot, and we have attempted to consider that. But at this point, Judge, I just have not heard anything from him.
Okay. All right. Then I will grant the relief prayed for on the motion to compel also. Ms. Nettles, if you want to post that to me in chat, I will sign it.
Thank you, Your Honor.
Okay. All right. And Ms. Gonzalez, either Judge Ellison or I suppose we'll see you on the 5th.
Yes, Judge. Thank you so much.
You're welcome.
Ms.
Mr.
Nettles,
Richmond, did you have anything?
No, Your Honor. We're set for, I believe, June the 22nd. So we're fine, Your Honor. And I appreciate this.
All right. Then you're excused. Okay, Mr. Richmond.
Yes, sir. There are a few housekeeping matters on some stuff I have, and I was wondering if I could talk, if you had a few minutes to go over them.
Not right now. I can call you on your cell. This is nothing that's on the docket today, or not on the.
No, there's nothing on the docket that I have.
Okay, yeah. I will call you whenever we get finished with court.
Okay.
Or when I'm at a breaking spot. I've got people lined up to speak to me.
Okay.
Okay, and all right, in the Brighton case, where do we stand?
Yes, hello, Your Honor. We have been chatting in the conference room, and we have come to a couple of agreements on temporary orders. The one thing that we have not agreed to is I would like you to speak to the child today. As I said, the child is 15. This action was filed based on an outcry of the child, of things that were going on in her mother's house that were making her uncomfortable. And so that's why the father filed this motion to modify. We originally had this matter set before you on April the 22nd. However, when Ms. Hewlett took over as the attorney for the mom, she was hired and she had a vacation letter on file for the 22nd. So I agreed to reset it for today to give her time to enjoy that vacation that all attorneys need to enjoy. And so now they have filed their answer for today and their motion to transfer. There is no counter petition on file. There are no affirmative requests made by the respondent. And now Carolyn Hewlett is telling me she's going to announce not ready and that she wants a continuance. There is no motion for continuance on file. And we have a Rule 11 agreement where I moved it from April 22nd to the 28th. It was after we signed that Rule 11 agreement saying that we would have it heard today that she then went in and filed a motion to transfer. In all of our previous conversations, she never advised me that her client had moved right over the county line. The child still goes to Lavernia ISD, despite the fact that her mother moved a couple of miles away. So in the Rule 11 agreement, she did not tell me that she was going to file a motion to transfer. So I feel that it is a strategic move to delay this and have the child's voice not be heard. I know it is a mandatory transfer because they've now lived in Guadalupe County for 6 months, but I also know that the rules say that this court can make temporary orders until we get over there. I find that when there's a motion to transfer, it takes anywhere from 30 to 45 days to get back into court because Wilson County has to bundle everything up, get it certified, send it to Guadalupe County. They have to docket it, then they have to put it with the judge, then we have to get on their calendar. So it could be a while. So my plea to the court today, Your Honor, is to go forward with today's hearing on temporary orders. We have agreed to a CCE. I've given her 3 names for her to pick from, and I'll let her speak to which one she likes. If not, then she can give the court 3 names. We've agreed, I believe, on app close. and that the parties will check it once a day and return answers to any questions once a day, that there will be a mutual injunction not to talk to the child about the case. But Your Honor, this 15-year-old wants to come live with her dad, and I would like this court to let this child have her voice heard today. My client is prepared for whatever you say. Once you talk to the girl, if you feel like she needs to stay with her mom until we can get over to Guadalupe County, fine, then that's what's going to happen. If Your Honor believes that she needs to go to her dad until we can get over to Guadalupe County, fine, then that's what will happen. I just think that her voice needs to be heard. I think that if we suppress her when she's the one who came and made the outcry to her dad, I think that if she is told, sorry, the court didn't want to hear you today, I think that may cause some problems with her because she's feeling like she can't talk to somebody. So that's all we're asking today, Your Honor, is that these items that we've agreed to, that the court validates them and orders them, and that you spend time talking to the child. And we are fine with the mother. The mother lives about 6 miles from the high school, and the dad lives about 3 miles from the high school. So we're fine with the mother going over to the high school, taking her out of school, giving her her iPhone, and letting her sit in the car while the mother is outside of the car to talk to you alone. Thank you, Your Honor.
Ms. Hewlett?
Yes. I was hired on this.
Okay, I mean, is there another electronic device on near you?
I believe it might be Miss. Okay, I think now that Miss Lopez is muted, I think, is it better?
Yes.
Okay, thank you. I was hired on this matter on the 16th. I did have a vacation letter on file. I reached out to Miss Lopez before even speaking to my client about anything, and she was very gracious. There was a miscommunication between our offices, and on that Wednesday, the 21st, right before I left for my vacation, there was a miscommunication about whether it was going to be today or May 5th. We have made diligent efforts to subpoena counselors and CPS workers. We have no problem having temporary orders in front of you, but in order to be able to give a full picture of this case, which includes this 15-year-old who was sexually assaulted by her stepbrother.
Objection, Your Honor. Facts not in evidence, and that is not the truth at all.
Okay.
Which is why we'll have a CPS worker who is we're subpoenaing them to be here, the counselor to be here, the medical records to be here, so that you can have the full picture of what this little girl has been through, and we understand that she's going to have her chance to voice her opinion, but I believe it's important in order for you to be able to make the facts regarding the best interest of the child, that the professionals in this case be heard. And it is correct that I don't have affirmative relief on file as of right now, although that was part of the reason I had called yesterday to talk to her about some of these issues. And she did agree to the the child custody evaluation and the injunction regarding speaking about the case. So some of the issues.
Right, and you're breaking up, ma'am. Ms. Hewlett, I heard that she agreed to the child custody evaluation, and after that, I've heard very little. I don't know, Ms. Cavazos got it, but I did not.
So at this point, the case is a mandatory transfer to Guadalupe. If temporary order, this late in the game of school being over, there is no urgent matter that would be needed. But if all we're really needing is a week to be able to get our witnesses subpoenaed that are necessary to be able to give you a full picture. However, I do believe that I could send her an agreed order. I don't think it would take 45 days to get in front of Guadalupe, but regardless, I do think this child having to come in and testify in front of 2 separate judges is not necessarily in her best interest. But if that's something that the father is insistent upon, and all we're asking for
we'll move ahead today. There's no motion for a continuance on file, is my understanding. If there was, it would be denied, so we'll move ahead today. If let me work on some other things. If the attorneys feel it would be appropriate to meet with me in a breakout room and let me know about some things that I might need to discuss with the minor in chambers, I'd be glad to do that also.
Thank
we
you, Your Honor.
Appreciate meeting with you in a breakout room.
And which parent should go to the school, Your Honor?
If you have an agreement the mother's going to do it, that's fine. It doesn't matter to me.
Okay. Carolyn, you want to have her go over there now?
Okay.
Thank you, Your Honor.
All right. All right, Mr. Nichols, Mr.
Yes.
Cedillo, do you all
Yes,
have
sir.
anything?
We are gonna need a hearing.
All right, how long?
I think 30 minutes.
30, 45 minutes, Your Honor.
All right, Ms. Mendez, I'm going to ask you to unmute.
Okay.
All right. Do you have a proposed divorce decree?
I do. I turned it in. I believe I turned in everything I was supposed to.
Okay. Is it signed off on by Marco Mendez?
Yes, I got a waiver. He signed it and everything.
Yes. Well, you did get a waiver, but after you got the waiver, he came in and filed an answer.
I'm sorry, can you repeat that?
You did get a waiver from him, but one, it was only a specific waiver. He waived citation. He didn't waive appearing in court. And two, after or at the same time he filed that waiver, he filed an answer. And once that happens on either of those, you have to either have his signature where I can see that he's agreeing to the entry of the divorce, or you have to have sent him notice letting him know that he had to be in court today because this was the trial. So have those things happened?
No, we didn't do that then.
Okay, is he around?
No, it's kind of hard to catch him, to be honest with you.
All right, ma'am. Well, what I will suggest is, let me look at his waiver. Okay, did you get a, it's not pulling up, hold on. Okay, and he has an email address that he put as his contact information?
Yes, I believe so. Yes.
All right, you need to, and you can do it through chat if you want, but you need to get with the court administrator's office, and you can get with Ms. Riley, who's online, get a date, a couple of 2 or 3 weeks down the line, when this is going to be, can be set, and then give him notice of the trial setting.
Okay.
All right, now, before we go any further, let me let you know a couple of things. One, are there children involved in this case?
We do have 2 children together, and I already have court ordered child support already.
Okay, all right. Then what needs to happen is there's only supposed to be 1 case involving the children. So if you want to do something different than what the court order is, and I assume that's an attorney general's case. Is that an attorney general's case? Did you go through?
Yes.
The attorney general's
Yes.
office? Okay. The easiest way to do it is just to get a copy of the order in the attorney general's office case and attach that to your divorce decree and say that I'm just going to adopt whatever that order is. I'm going to make it the order of the court in the divorce.
Yes, I did turn that in with the final.
Again, ma'am, I haven't seen that, and it doesn't matter because we can't go forward today. The other thing I need to tell you is, when did the 2 of you marry?
I want to say it was 2006, I believe.
Have there been any other children born to you since that day?
Yes, yes, I have a son.
Okay. Did the Attorney General's case also adjudicate that your husband is not the father of that child?
No, I have the court in June
Okay.
for,
All right, then this needs to be set after that happens, because the law presumes that the husband is the father of every child born during the marriage, and I think for 270, 290 days afterwards. So if he is not, then the only way we can refute that is either with DNA testing, or there's also some paperwork you can sign where the biological father, the husband, and the wife all sign affidavits with the Attorney General's office saying that the husband is not the father and the biological father is the father. So again, you're going to have to prove that up. If you're going to have that done in the Attorney General's case, it would be certainly easier in your divorce decree to wait until that happens, and then you can just attach a copy of that order to your divorce decree also.
okay, sounds good.
Finally, the law in Texas presumes that everything a married person owns is community property. Doesn't matter whose name is on it. Doesn't matter if you and Mr. Mendez have a dispute over it or not. If it's you own it right now, the law presumes it's community property. So anything that either of you own that is valuable enough, there might be a lawsuit over it one day. You need to spell out who gets it, either that it's community property and it's being split up, or that it's not community property because say you owned it before the marriage and therefore it's not being split up, and who owns it. If that doesn't happen, the law presumes the two of you still own it together, even though you're divorced. In 20 years from now, if one of you gets in a wreck with no insurance or not enough insurance and gets sued, your creditors can go after the ex-spouse, claiming that they're entitled to part of that property. Okay, so just to make sure you have everything done that you need to have done in your in the divorce decree, all the property spelled out. Okay, so we will see you in June or July after the Attorney General's case is finalized.
Okay, thank you very much, Judge.
Okay. All right, give me just a moment here.
And Judge, one of the Assistant Attorney Generals did come in on the Zoom hearing. I believe she's on the Foster case.
Okay.
Mr. Nichols.
Yes, Your Honor. Lauren Reed with the Office of the Attorney General.
Okay, and all right. And is the AG's office, is that part of the, are you part of the hearing today or?
Yes, Your Honor. It appears that this is a case that we filed a non-agreed child support review order. Mr. Foster and his attorney filed an answer with an objection to the district, or pardon, to the associate judge. So we referred it up to this court. I mean, basically it's a suit in affecting parent-child relationship hearing. Either we go with the one that the OAG did, we negotiate a new one, or the court orders something different.
Okay. And let me ask the attorneys who've been conferring, do you need to confer again now that the AG's here, or no?
Well, Judge, from our perspective, there's nothing set today. There's nothing. The only thing that's set today is my client's request for temporary orders regarding possession and access. He hasn't seen the kid and can't get the kid. There has not been, there is no setting today on support.
Your Honor, my.
Okay, and that's fine. I don't want to, I just want to know if it'd be help to confer or not. The answer I'm hearing is no. How long to hear that case?
I think 30 minutes on access and possession, it's not remarkable at all.
I think about 45 minutes, Your Honor.
Ms. Reed?
Your Honor, our office does not take any position on the access.
Okay. So 45 minutes. Give me just a moment. So we're finished with Atascosa County, finished with Karnes. Okay, Mr. Cedillos, on your name change, are you ready to go?
Yes, I am, Your Honor.
All right, go ahead, sir.
Were you talking to me?
Yes. Everything else is contested.
Well, Your Honor, I guess the child support, I mean, my pleadings do reflect that we are asking for temporary orders on child support.
All right, now I thought this was a name change.
Oh, I'm sorry, on the name change. No, I'm sorry. I didn't hear you, Your Honor. No, we're not ready on the name change.
All right,
I don't
so
know,
does
my
it need to be
client-
reset, or are you going to?
Yeah, we're gonna have to reset it because we told my client about this today's setting last week, and then I've been calling him this morning, and I have got no answer.
Okay, I will put reset on request. If he manages to make it in before I'm finished with court today, we will take it up then.
Okay.
All right, so is that all you have, Mr. Cedillos? Andy, is that all you have?
Just the KJF child. That's the only thing.
All right, what cause number is that?
CVW 2000-764.
Okay, that's the foster case. All right. Okay, so let me pull that file. And Ms. Tejada, I just posted the two signed Riley orders, the clarification and the motion to compel to you.
Yes, Judge, I got them and I've accepted them. Thank you.
Actually, let's take about a 11-minute break. I need to return a call. We'll be back at 20 after 10.
And then, Judge, are we hearing Foster?
We'll take up Foster and then Brighton, although I may break if the Brighton child becomes available and speak to her in a breakout room.
Thank you, Your Honor. See you shortly.
Okay, I'm back. And let me ask. I have the court's file. What is set for hearing today?
Our request for temporary orders, Your Honor.
And I see that there's a notice of setting from the 22nd for your special exceptions and the motion for temporary orders. Is there anything else set today?
Well, Your Honor, my pleadings, my counter petition does ask for child support. This case was originally set in the Attorney General's office, and there was a review meeting to try to set child support at that time, but there was an objection.
Okay, and so does the AG's office have anything set?
No, Your Honor, we're not aware of this setting, so we didn't set anything for today.
Okay, all right, so are you, and on the temporary orders, is there anything in the temporary orders that the AG's office is a mandatory party on, Mr. Nichols?
Not on my setting, it's not. I mean, I did give notice by e-file of the notice of hearing once we got the approved setting from, I guess, your court administrator. We issued the notice of setting and served everyone on the e-service list. I think it's whatever the email is, CSV, but I don't think the AG has a dog in today's hunt.
All right.
And I have no doubt that that's true. It can be a convoluted process to get it to the attorney, and sometimes it doesn't work out. So I'm sure that Mr. Nichols did everything right, and it just didn't work out on our end.
All right.
Your Honor,
so we can excuse Ms. Reed?
I have no objection to excusing Ms. Reed.
Mr. Cedios?
Well, Your Honor, since we're here on temporary orders, I mean, we requested, my pleadings for relief for child support. I mean, I don't see why we can't take care of it. It's not like it's no surprise.
Okay. Mr. Nichols, are you objecting to hearing the other parent's motion for temporary orders?
I have not prepared my client for the temporary orders and don't have the exhibits and all that today. I mean, if the court wants to just take testimony, I mean, I understand that it needs to be heard at some point, but that I have the information today to put on testimony regarding that. Well, I certainly don't have information to put on exhibits. Okay. I guess Mr. Foster could testify as to what he recalls or his best information about net.
All right, we're either going to have a hearing or not. So I'm hearing the answer is we're not. And Ms. Reed, you are excused. Do we want to go ahead and set a date for Mr. Cedios' temporary orders?
That's fine. Are you not hearing any temporary orders today? I'm sorry? Are you not hearing any temporary orders today?
No, just on Mr. Cedios' motions. I'm just trying to get a date so we don't have to go through this again. What date do we need to hear Mr. Cedios' orders? 5/5, 5/8?
I can do 5/5. I cannot do 5/8, Your Honor.
5/5 is fine with me.
Okay, is that my day, Ms. Riley? Because
no, that date is actually with Judge Ellison, and that date is actually full.
Okay.
The 3rd, the 10th, and the 12th.
Okay.
Let's see, and yours is, you're on the 12th and the 3rd, actually.
Okay, 3rd and the 12th.
I can do the 3rd. I mean, that's Monday. I mean,
It's in person as well.
I mean, I don't want to cause the court to do more work than it needs. So to the extent that we can take evidence, and whatever the evidence, if the court wants to assess the child support obligation, that's fine.
All right, well then let's start with that. Call your first witness, Ms. Reed, or if you have opening statements, go ahead, Ms. Reed. I'm going to ask you to stay on then.
Okay.
Even if we don't get it finalized, we'll put on testimony today.
Thank you.
So, you want to have an opening statement?
Yes, just a brief opening statement. Your Honor, this is a case involving Carson Foster, a young boy who is about a year, almost a year and a half, coming just shy of it. My client is the acknowledged father from birth. These folks both live pretty close to each other in the Floresville area. But he has not been able to see his kid. It always comes with some stipulations. Oftentimes it's stipulated that he has to engage with mom and in a more than a co-parenting role. And so we are just trying to get a order in place that gives him court-ordered visitation. May I share my screen, Your Honor, so I can tell you what the relief we're asking for?
Yes.
Your Honor, this is I apologize. Can you see the annotated? Is that on your screen?
Well, it's not annotated. I see a calendar, but it's for July of this year.
Okay, let me get there. Is that one better?
Yes.
All right, so Your Honor, we're asking for a graduated schedule, basically leading up to something that mirrors standard during the pendency of the case. We are asking for May that my client have 8 hours on, that's no overnights, but 8 hours on Saturday and Sunday on the 1st, 3rd, and 5th weekends of the month, and then 4 to 7 on the intervening Thursdays. Then graduating to that same schedule, just 10 a.m. to 6 p.m. on Sundays, which would be 1 overnight. That would be 2 overnights the following month. And then the following month in July, do Friday afternoon till Sunday at 6 p.m. on those same Thursdays. We think that this is, the evidence is going to show, Your Honor, that there is no basis in the law to deny that there's no risk, there's no harm, there's no factor that exists that would keep my client from having as much visitation as the law and the court would allow. And we think that that's the best interest of the child. And that's why we have come up with a graduated schedule, because again, the father has not been allowed to spend any meaningful time with the child in a while, unless it comes with stipulations imposed by mom. So that is the relief that we are requesting today. With that, I'll close my opening statement, and I'm prepared to go forward after Mr. Cedillos makes his.
All right, Mr. Cedillos.
Yes, Your Honor, the child is 15 months old, and there have been some efforts to try to get some kind of visitation by agreement. Ms. Munoz is concerned about for this child, because he can't articulate at this time anything. There'll be some testimony about Mr. Foster living with somebody else, and that's one of her concerns. She'll also testify that when they lived together, Luke and Carla Munoz, she mainly took care of the Mr. Foster's other child. So we feel that Mr. Foster isn't always needs a female to assist them with taking care of the child, Your Honor. We'll present evidence to that effect, or testimony.
And does the AG have any statement?
Your Honor, today the state is just requesting that the court take testimony as to the income and medical support available and set support pursuant to Texas Family Code.
All right, and we'll try to get that testimony in first. Your first witness, Mr. Nichols?
I'll call Luke Foster, please.
All right, and who all do we need to have sworn in?
No one.
Luke Foster, how about Carla Garcia?
Neither one have.
Any other witnesses?
No, sir.
All right, let me ask Luke Foster and Carla Garcia to raise your right hands. Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth. So help you God?
Yes, Your Honor.
All right. Go ahead, sir.
And is it the court's directive that I get some of the resource questions out?
Please.
Okay. Mr. Foster, how are you currently employed?
Work for CPS Energy. I've been there 18 years.
Okay. And what is your gross salary, if you know it?
My gross, I believe, I usually take home, about 1,200 every 2 weeks. So I'm thinking maybe around 5,000 or 6,000 maybe a month after everything's taken out.
Okay, so what do you get in the bank from each paycheck?
Well, about 1,200.
1,200, and you're paid twice a week?
Yes, twice a week.
Twice a week or twice a month?
It's every 2 weeks I get paid.
Okay. And just so we don't have to come back over it, is that every 2 weeks or is that twice a month?
Yeah, I guess it would be bi-weekly.
So do you get paid 3 times sometimes in a month?
Yeah, I guess.
Okay.
All right. Okay. So you said 1,200 and bi-weekly. So if you multiply that by a year, and you said that's what your take home is. So your take home would be around $31,200 a year. Is that right?
Yeah, I mean, after everything's taken out, yeah, that's about right.
And when you say everything taken out, do you have any optional expenditures, or all those expenditures mandated by taxes, or?
Most of it's mandated by taxes. I do have an extra retirement set aside for my future retirement for my children, but that's set off the side.
And about how much is that per month?
I believe I pay, I think it's every $200 every pay period.
And that is an optional contribution.
Yes, that is optional.
All right, so if we have 4 times 26.
Mr. Nichols?
36,000.
Mr. Nichols?
Yeah, okay. Yeah.
Hear me?
Well, your picture is still frozen. I heard if we have, and then nothing since then.
Hello?
Yes, sir. Can you hear us now?
Oh, can you hear me, Your Honor? Yes.
Yes.
May I proceed? I'm sorry.
Well, and just
I'll
let
go
you know,
back.
I heard if we have, and then nothing else.
Okay. So if we take what I would submit is $1,400, because that $200 you're choosing to save. So 1,400 times 26, would you agree with me that your net a year is $36,400?
Yes.
And then if we divide that by 12, that would make would you agree that your net monthly resources would then be $3,033?
Yes.
And if you have another child that you're obligated to support?
Yes, I have my 5-year-old daughter.
Okay, so under the guidelines, I believe that means you would pay approximately 17.5% of your net monthly resources. Would you agree with that?
Yes, from what I'm hearing, yes.
All right, so if I multiply 17.5% by $3,033, I get $530. Does that sound about right with 17.5% of your net monthly resources right now?
Yes.
Okay. Everyone else will have a chance to cross. Do you want to allow cross on that first, Judge, and then?
Please. All
Okay,
right, so
then I'll
Mr.
pass
Dios?
the witness.
Mr. Cedios?
Luke, Mr. Foster, you only have one other child?
Yes, I have a 5-year-old daughter.
And what's her name?
Avery Foster.
Okay, so it's your contention that your monthly net is $1,400 a month?
Yeah, I would say about, yeah.
No, I'm sorry. I have to clarify the testimony, Your Honor. I think that was inaccurate. Mr. Cedios and Mr. Foster, I think you testified you get $1,400 every 2 weeks.
Oh, yeah, every 2 weeks. I'm sorry, not monthly. Yeah, every 2 weeks.
Okay. How much do you make an hour?
About $31 and some cents.
You don't know how many cents?
I don't have the cents offhand.
Okay. Do you know how much you pay? Do you have health insurance?
Yes, I do. And I, at the time that CPS was doing the insurance, I tried to get Carson added on my insurance and told the mother I needed his social security number and birth certificate, and I couldn't get any of that. So I missed the deadline on adding my son to the insurance.
Okay, how much is insurance for Carson?
Well, I have no idea because I don't have Carson on my insurance.
Okay, do you have to pay for your insurance?
Yeah, I pay myself and I have my daughter under my insurance.
Okay, is it a family plan or is it per child?
Yeah, I believe it's a family plan.
How much do you pay for Avery?
I can't recall, sir, on that.
Okay, but maybe I didn't hear this correctly. You don't pay for your own insurance, is that correct? CPS pays for your insurance?
No, I pay for my insurance through CPS. I have Blue Cross Blue Shield, but it gets taken out of my paycheck.
Okay. I'll pass the witness to the Attorney General's office, John.
Ms. Reed?
Sir, for your other child, for Avery, you went to court and got a court order for that case. Is that correct?
Yes, ma'am, it is.
Okay. And so at this time, I would ask the court to take judicial notice of the court cause number 1807-0530 CDW, which involves the child Avery Foster.
All right, is there any
Sir,
objection?
No objection.
No objection.
Without objection, I'll take judicial notice of all of that.
Sir, the court order was signed August of 2018, so about 2.5 years ago. Are you making approximately the same or more or less?
Actually, I'm making less because I'm at a location that offers no overtime. So I basically, the location that I'm at now, I make about $20,000 less than what I made because my overtime was where I was getting paid, but that's not guaranteed overtime. That's when, storms happen or whatever, I might get called in, I might not, but that's not guaranteed overtime. It's, I specifically get paid, what I get paid an hour is $31 an hour. And right now I'm not making anything near to what I was making. I think last year I made like 70 something thousand. The previous year I made, closer to 90. But like I said, I'm not getting the overtime that I was getting.
Are you a guaranteed 40 hours a week?
Yes, I am guaranteed 40 hours a week. Yes, ma'am.
Okay. And according to that paperwork, you were providing health insurance at a cost of $200 per month for your other child. Would this child be on that same plan?
Yes, ma'am.
Okay.
I'm sure probably a couple of numbers that have changed there since then, but it's probably pretty close to, what it is.
And does your employment also offer dental insurance?
Yes, it's all on the insurance that CPS offers is dental, I think eye vision and the regular health insurance. So all three of those are fine.
Okay. And then do you have any other children other than Avery and the one we're talking about today?
No, ma'am, just the two.
Okay, I have no further questions for this witness.
All right.
I have nothing.
Okay, and does the AG need to remain for anything else? Mr. Steele, are you claiming there's special circumstances that the guidelines need to be exceeded or anything?
No, Your Honor.
Okay, then I will release the AG's office. Thank you, ma'am.
Thank you, Your Honor.
Go ahead, Mr. Nichols.
Thank you. Mr. Foster, you have a daughter who is 5, you said, is that right?
Yes, sir, it is.
Can you describe how often you see her?
I was on a court order. I was offered standard visitation. It was a Thursday and every other weekend, but me and her mom have came to a civil agreement that whenever my daughter wants to come with me, which is for maybe even
Let me stop you there, Mr. Foster. So regardless of what the court order, whatever y'all agreed, what are y'all actually doing?
pretty much anytime my daughter wants to come with me, she comes with me. I call her mom. Her mom calls me.
How much? That's not what I'm asking. How much time do you actually see her?
About 4 or 5 times a week.
Okay. Does she spend overnights with you?
Yes, she does.
What is your living situation?
I have my own house. You know, I live a mile up the road from my daughter's mom, so it's very convenient.
Okay. How far away do you live from Miss Munoz?
I don't know exactly where she lives, but I can almost guarantee it's probably less than 5 minutes from my location.
All right. Do you have ample furnishings and food necessities? I mean, do you have everything in a house that
Yes, sir, I do. I have everything that I'm supposed to have for my child that they need there. You know, I'm a good dad. I'm a good father. So.
Did you care for Avery when she was the age that Carson is now?
Oh yeah, yes, sir, I did.
Are you familiar with taking care of a 15-month-old boy?
Yes, I've changed numerous diapers. You know, I still take my daughter to the restroom when she needs to. She's 5 years old. I'm very capable of taking care of a child, even an 18-month-old.
Has a child ever been injured or hurt or damaged while in your care?
No, neither of my children have ever been in any kind of harm whatsoever.
Have there been any CPS investigations regarding either child?
There was a CPS investigation with my daughter, and that was false accusations brought upon me, and all of that got dismissed.
Was it ruled out?
Yes, it was ruled out.
How long ago was that?
I want to say it was probably maybe almost 2 years ago.
Okay. But it's your sworn testimony that was ruled out, not unable to determine, but actually ruled out.
Yeah, ruled out. Doesn't exist.
Okay. Is there any reason why you could not provide for Carson's needs and not once, but all of his needs?
Absolutely no reason whatsoever. I can provide for my son, and on my behalf, I feel like I can do a better job than his mother.
Well, do you feel that there was some illusion and opening argument that you need a woman to take care of your kiddos? Is that true?
Yes, I mean she said that I needed a woman to take care of my kiddos. That's false information. I don't need a woman to take care of anything that I need to take care of for my kids. I can do it myself.
All right. What is the access and possession schedule that what access have you had to Carson in the last few months?
None.
Been born?
I haven't got to see my son basically in his whole first year of this past 2019. I haven't really got to see him much at all. Every time I've tried, you know, I was told no, or I have plans, or she would tell me yes, and then she would pull the rug underneath me and say, "Oh no, sorry, we have plans." So I haven't got to see my son in a whole year, and I've been trying and trying. Numerous text message of me trying to get my son and spend time with my son, and every time I'm told no or disregarded or ignored.
When was the last time you actually set your eyes on Carson?
I saw him, I want to say probably nearly 2 months ago at a dentist appointment, and it maybe lasted 45 minutes.
Okay, and before that time, when was the last time that you had Carson?
I couldn't even tell you. I mean, it's been that long. I haven't got much. I would probably say maybe Christmas, and that was only because my girlfriend that I have now reached out to Carson's mother and requested that me seeing him for Christmas, and Carla would only agree to 1 hour, and so I got to see him 1 hour on Christmas, and it was hard because I didn't want to give him back, and I told her no, I want to spend time with my son, but my girlfriend had told me no. That's not who you are. I'm trying to get you more time with your son. You need to give him back. And so I did give him back within that hour.
All right. Let me ask a few questions about your girlfriend. How long have y'all been dating?
We started dating in August of 2019.
Okay.
Oh, no, 2020, I'm sorry. We're in 2021, so 2020 of August.
Okay. And what does she do for a living?
She works with Lackland Air Force Base. She dental assistant.
Okay. And I know this is a sort of a, don't take this as an offensive question, but is she required to register as a sex offender?
No.
Is there any reason or criminal history or circumstances that would would cause concern to a reasonable person about if Carson was around her?
No, we had one little fallout, but it's got ironed out. She hands on me, but I found out in her art that she was very sincere about it and that she would never do it again. And I feel like I see her around her son and her daughter, and I see her around my daughter, and there's no, she's not a mean person into them kids at all.
Okay. You saw the schedule that I put up on the screen for the judge earlier. Why do you think that is? Well, first of all, do you agree with me that that's what you're asking for today?
For today, yes, I am.
You understand that this is temporary orders and it's not necessarily the final possession and access schedule.
Yes, it's hard for me to agree to that because I want my son half the time. I want 50-50, but I know the circumstances of me not seeing my son for almost a whole year. I want to make, and my son, the last time I seen him at the dental office, he ran to me, so he knows me. It's just, I want to get a schedule where I can start seeing my son on a daily. And if that requires me having these temporary orders to get some kind of visitation for my son, to me, that's minimum. And I couldn't,
Okay. All right.
but more with getting some kind of visitation started for temporary.
All right. So, but do you believe that the proposed schedule, which at least for the month of May would have you no overnights, but 6 to 8 on the first, third, and fifth Saturday and Sundays, and then for 3 hours on the intervening Thursdays?
Yeah, that's really giving. That's more than fair.
Okay, but can you tell the court that you can handle that? That means
Handle that. Yeah, for now, yeah, I can handle that. Yes.
And the reason that we did 4 o'clock on the Thursdays, why was?
You broke up, Justin.
Okay, when we did 4 o'clock on Thursdays, why did we do 4 o'clock?
Because that's around what time I usually pick up my daughter.
Okay.
And I usually pull into town because I work in San Antonio. And so usually I pull into town around 4 o'clock.
Okay. And then do you have any concerns about doing overnights in June?
No, not whatsoever, none.
Okay, and then it's pretty much what we call a standard possession order in July. Is that something that you'd like to look forward to?
Yes.
Now, what kind of stuff why do you want the overnight? Why do you think that's important, the extended periods of visitation?
Because I seen my daughter at a young age, as Carson's age, go through what basically I don't want from my son, to see him every now and then. I had to pry my daughter off of me because she wanted to come with me all the time. And it's so important that I start getting some time with my son so I can bond with him and do things with him and have memories like what I had with my dad. I lost my dad 2 weeks ago. And that's what I look back to, is the memories that I share with my dad as a younger boy, and till I was 16 when he left. But I cherish that. And I want that same thing for me and my son. I want that same thing for me and my daughter and my kids.
Okay. Is there anything else that you want Judge Wilson to know or consider today when making a decision?
Judge, I'm telling you right now, I'm the most loving dad, father person that you're going to run into. I'm a mean bone in my body. Some people, they've accused me of things, but I'm a good man, and I just want what's best.
Your Honor, I'll pass witness.
Mr. Cedillos?
Mr. Foster, do you have a car seat?
Do I have a car seat?
Yes.
For Carson, yes, and for my daughter. So
Okay.
yes, I have both.
Okay. Carla wanted me to make sure you do have that. But you say you only saw the child on February at the dentist appointment, and then in Christmas?
Yeah,
last year?
unfortunately, yeah.
No other times?
Before that, yeah, I've seen him a little bit.
Okay. And was Carla going to allow you to do an agreed visitation on Father's Day last year?
Yeah, she totally stood me up. For Father's Day of last year, I told her that I would pick him up at 11, and I was at the ranch that weekend. And when I was pulling into town, it was 10:30. And I said, hey, I was going to swing by the house and get cleaned up, take a shower. And I said, could we push it back to 12? That way I can get home and get cleaned up and go pick him up. And she said, no. I said, okay, well, then I'll pick him up now. And then her text message back to me was, oh, no, sorry, we have plans already. Have a good day. Happy Father's Day. And that's what my response was.
Okay, but this arrangement had been set up even before that day, right?
Yeah, it was already set that I was supposed to get Carson at between 10:30 and 11, and I was on time for that. All I had said was I was gonna go get cleaned up at the house and get my AC turned on and everything. That way, when Carson came over, it'd be comfortable in there. But when she disagreed to that, I said, okay, then I'll come pick him up now. And that's when she threw it back at me. Oh, sorry, I have plans already. Happy Father's Day.
Okay, sir. So I'll have a different presentation about that. But when y'all lived together with Carla, is it true to say that she went to the grocery store one day and after about an hour, 45 minutes, you had to call her, ask her to come back, take care of your son?
I think when I was watching him, she had told me that call her if he's upset or anything like that. And I didn't know if it was going to get thrown back in my face, but I can take care of my son when he's crying. But she told me, hey, if he's crying, let me know or whatever. I did it out of the good of my heart to let his mother know. I didn't do it because I couldn't handle it. And I didn't tell her, hey, you need to come get Carson because I can't handle it. It wasn't anything to do with that.
Okay. I'll pass the witness, Your Honor, for now.
Nothing else.
I'm sorry?
Nothing else, Your Honor.
Okay, any other witnesses?
I'll call Miss Munoz.
Go ahead.
Miss Munoz, could you just state your name for the record?
Carla Munoz Garcia.
Where do you currently reside?
I live in Floresville.
What's the
Do you want the physical address?
Okay, and this is going out over YouTube. We don't have to have the physical address broadcast over YouTube. I will, unless you're making a motion for protection for family violence or something, I'll direct Mr. Cedillos to post that in chat to Mr. Nichols.
Yeah, if we, Your Honor, I think the purpose of that question, the social security number, was just so that my client has the information. So if we can have the understanding that they need to provide that and move on.
I'll provide that.
Okay.
Okay, go ahead, sir.
Okay. Miss Munoz, do you currently control when Mr. Foster can see his son?
Do I control it? No.
Okay. Are you the gatekeeper for when he gets to and doesn't get to?
What do you mean?
Well,
Do I provide transportation for my child?
No, do you review requests from Mr. Foster and either grant or deny those requests for him to see his son?
I have not gotten any willingly text messages from him to get my son.
Is it true that you only allowed Carson to be with his father for 1 hour on Christmas?
No, it was actually 2 hours. And his girlfriend did reach out to me after I had reached out to her, asking her to stop bashing me on social media. And then after that, her and I kind of got to know each other and we started communicating. Then when she reached out, I reached out to Luke and said that she does not need to be our middleman and that if Carson was
Yeah.
allowed to go over
Asking
there,
about the hour. Was it, you said it was 2 hours, not an hour.
it was 2 hours. It was
Okay.
not 1 hour.
Okay. And do you, as you sit here today, have any evidence that Mr. Foster is a danger to his son or any child for that matter?
No.
Okay. Do you have belief or any evidence that Mr. Foster lacks the skill set to care adequately for Carson?
If one thing that happened when Carson did go over the first time is evidence, then I can explain that real quick.
Okay.
Carson went over and Luke was supposed to change his diaper. He came back home with a rash. I called Luke and I asked him if he had seen the rash, and he said yes, but he didn't put ointment on it because when he wiped, he didn't cry.
Okay.
So it just makes me concerned if he's not going to take the proper care of my child.
Okay. You saw the schedule that I put on the screen, did you not?
I did.
And do you believe that that is acceptable?
I don't, unfortunately. I think for the best interest of Carson, he needs to grow comfortable to, getting to start a relationship with his father again. I proposed one to my attorney. I don't know if you guys have seen that yet.
No, I have. I don't want to get into any settlement discussions. The calendar I've posted is what we're asking for today. So I want to know specifically why you do not think that calendar is in the best interest of Carson.
I am not comfortable with Carson having any overnight stays. He is 16 months old. He's seen his father maybe less than 15 times since he's been born. I just truly don't believe that getting Carson out of his routine is the best interest from him.
Okay, but why isn't May in the best interest of Carson then? May doesn't have overnights as we've proposed it.
What was that? May?
May doesn't. May just has 10 a.m. to 6 p.m. on Saturdays and Sundays for a month.
That's after a month of Carson getting to know him. I would feel more comfortable with Carson starting sleepovers at 4, like his daughter did.
You really don't think that my client should have an overnight with his son until he's 4?
Until Carson can verbally tell me that he is comfortable at his father's, I think that is the best thing for Carson.
Okay. Do you have any basis besides just your beliefs? Are you trained in childhood development like that?
Do I have any beliefs?
No,
What do you mean?
besides your belief that that's not in the best interest of Carson, do you have any medical reports, diagnoses? Is there an illness, sickness, some reason why you're basing that belief that you think a father shouldn't have an overnight with his son till his son can verbalize that he's comfortable?
Not medical reasons, but because of Carson not seeing his dad for 16 months, him being in and out of his life, it's just not. It's just not in the best interest for Carson.
Have you ever allowed overnights at any time in Carson's life with his father without you?
No.
So it's your.
I had mentioned that if at some point we got to a very great co-parenting situation and Carson was comfortable, that it would be easier for us to do overnight stays, but that Carson needed to grow comfortable into having that relationship with his father.
My question, ma'am, is just, has Mr. Foster ever spent a night alone with his son since
No.
he was born? All right. All right, I will pass the witness, Your Honor.
Mr. Cedillos?
Ms. Munoz, how long did you and Mr. Foster live together when you had your son?
I want to say close to a year.
Close to a
After we
year?
had our son or before we had our son?
Well, after you had your son.
Three
I'm sorry,
months.
3
3
months.
months. He told us to, well, he told me that I needed to find a place to live April 30th 2020.
Okay. Did he ever spend the night with your son overnight, but alone? During
No.
that time? Okay. Now, you mentioned the 4-year-old that you wanted Carson to be 4 years old before you had any kind of overnight visitation. Why is that?
I just have lots of concerns and I don't trust his father. I truly just believe that house is unsafe. It's just not the safe place that I think is best for my child or our child. I think there's a lot of my concerns are the fact that if he's in a toxic relationship and is, allowing that to be around my son, I just don't want Carson to grow afraid of all of that. And here at my house, it's just me and him. So he has a routine. He knows where everything's at. I want to be sure and comfortable myself to know that my son is going to be safe with his father.
Okay, but with regard to Avery, what kind of visitation schedule did Mr. Foster have with Avery, his daughter?
Well, for a while, he didn't have access to her. Shortly after I came into the picture, he took her from a soccer game and her mom showed up. Then me and her started communicating, and then he started seeing her a little bit more. She would come over. I think he was trying to do court order, but they've never been strict about their court order. So he gets her when he wants. Now that she can speak, he gets her when she wants. Her mom did quote that
I'm
she was
going to
comfortable.
object as to hearsay.
Mr. Sidios?
You know what?
I'll ask the question. I'll rephrase the question, Your Honor. Did Luke Foster see his daughter did Luke Foster have overnight visitation with his daughter before she was 4 years old?
No.
Okay. And it wasn't until you came into the picture that visitation with Avery was overnight. Is that correct?
That what? That you're breaking up.
It wasn't until you were in the picture that overnight visitation was exercised by Mr. Foster.
After 4 years old, yes.
Okay. And that was because you were present.
Yes.
Is that okay? And that's your concern. You heard my opening statement, and that was your concern. That you wanted to make sure that Carson would be able to articulate any issues.
Yes.
Okay. Do you have any other problems with drinking and driving, or Mr. Foster might have?
I just have that concern that if he's trying to have overnight stays with Carson, that he's going to drink and drive with him. He has a habit of if anybody gets in an argument with him, he drives away, packs up his beer, goes for a drive, and I don't ever want Carson to be in the vehicle.
Okay. What kind of visitation schedule do you want to Mr. Foster to have with Carson? What are you proposing to the court?
I know sometimes they say, every other weekend. I would want Carson to see his dad. I'd feel more comfortable if he started seeing him, Tuesday, Thursday for 2 hours. He gets out of school at 4:30. As long as he's home by 7, he has a routine to go to bed and get in the shower and stuff like that. So if he's home by 7, I'm open to 2 hours after daycare, Tuesday and Thursday, and then 4 hours Saturday and Sunday every other weekend, at least for a month. And then after that, we can increase the time just so Carson grows comfortable to having that relationship with his father.
Okay. But you don't want overnights, is that correct?
I don't feel comfortable with them, no.
And is that because I'm going, the other, Mr. Nichols emphasized that he had another child. Was there always a female present when he was exercising his visitation with Avery?
Before that, I believe she met one more person. If not, I knew that I was the female helping him take care of his child.
Okay, so you do want some kind of gradual step up, first, third, and fifth weekend between your son and Mr. Foster.
I do eventually, yes.
Okay. And you have allowed your Mr. Foster to see the child. I mean, you haven't kept the child from him.
No, not purposely.
Okay.
There's a difference between keeping the child and then the father not asking for him. I had told him after I offered multiple times that I will not be offering my child to him if he did not want to take the responsibilities for him.
Okay. And you're willing to do weekday visits, but you need to have the child home at least by 7 o'clock so you can get him back in that routine.
Yes, so he stays in his routine.
Okay. And you're not living with anybody else, is that correct?
No, it's just him and I.
Okay. You said toxic relationship. Was that, you mentioned toxic relationship. Was that something that went on between you and Mr. Foster?
Yes, I believe our relationship was toxic, which is another reason why we chose to kind of end it. There was nothing good coming out of the relationship, and I didn't want my son to grow up around that. So being that I would say toxic relationship due to their incident, him calling his girlfriend a liar. I don't know how I could trust his girlfriend with my child if he's calling his own girlfriend a liar. And he has his own concerns about her that he expressed to me while they were on their break, but now she has the kindness of her heart. It's very hard for me just to have raised my son for 16 months by myself and then just hand him over to somebody who hasn't made the effort to be in a relationship with his son.
Okay. So do you want maybe the name, and I understand what the judge said about YouTube. Do you want the name of his girlfriend just so that you can talk to her, get to know her too?
No, I know her and I have her phone number. After that incident, I don't feel comfortable with her. So if Luke and I can get to a place in our co-parenting situation where we can just, not talk more than what we should, keep it to when he's getting Carson, if something happens to him, updates about Carson, then I think our co-parenting situation will be just right. But it's him having to take responsibility for Carson.
Okay. And you are asking for child support?
I am.
Guideline child support, and we've discussed this. It's based on his net income.
Excuse me?
You know that child support will be based on his net income.
Yes.
And he's got another child that he's got to raise, so he gets a credit for having to pay for another child.
Yes.
You know that. Okay.
Mm-hmm.
And you want medical health insurance, is that correct?
Yes, I do. I personally have my own medical insurance. They had told me that I can put Carson on my medical insurance, but that because we have an open case, they wanted to keep him on Medicaid, and then I can make the decision, or the judge could make the decision of whether he would be on Carson's or mine.
Okay. I'll pass the witness, Your Honor.
Go ahead, sir.
Thank you. Ms. Munoz, you realize that you're not entitled under the law to any greater deference or decision-making regarding your son than the father is. Do you understand that?
I'm not saying I have more entitlement than Luke.
Okay. Have you traveled with Luke outside the state of Texas?
With Luke, no.
And
Oh, actually,
no,
I'm so sorry. We went to
no,
Louisiana.
hold on. My question was with the child.
Oh, no,
Y'all have never traveled out of the state of Texas, you and the child.
no.
And besides your concerns, you don't have any evidence that Mr. Foster poses a danger to the safety and welfare of the child, do you?
Not physical evidence, no. It would just be what he's verbally told me.
And you understand that, I mean, what makes your preferred schedule of 4 hours? Why do you think that's better than 8? What makes you think that, you know, we're asking for 8 hours, you're asking for 4. What makes you think that you're right?
You're asking for 8 hours every weekend
Every other
or
weekend?
every other weekend?
Yeah.
Are you?
Yeah.
I just think that Carson needs to grow comfortable to that. I'm not trying to
If
please Luke
Carson's 16 months old, how do you know that he's comfortable with anything?
because he hasn't seen his father in a couple months.
Okay. And you
And I
understand
know,
that
I
you're
know
not
my
the one
child, and I'm not trying to please Luke. I'm trying to make sure my child's comfortable.
Okay. And you don't have any evidence that your child's uncomfortable with Luke, have you?
He's 16 months. How am I supposed to have evidence of that?
That is a great point, and I'll pass the witness.
All right, Mr. Cedillos?
Your son is still in diapers, is that correct?
I can't hear you.
Your son is still in diapers?
I'm still in diapers?
Yes.
Yes.
And you spoke earlier under direct cross-examination or direct that Mr. Foster had a problem with changing a diaper or when you went to the HEB one day. Is that correct?
I'm having trouble hearing your speaker.
Okay. Can you hear me now?
A little bit. They're cutting grass outside. I'm sorry too. I had to move, but
All right. You told us earlier your testimony was that there was an issue with diaper changing and diaper rash. Is that correct?
yes.
Has Luke Foster ever changed a diaper with Carson?
Yeah.
Okay. But you're concerned about do you have concerns about that? I mean,
About him changing a diaper?
yes.
I just hope that, yes, I have concerns. I hope that he puts ointment on him when he needs it. Instead of waiting to see if he cries, to see if it hurts.
Okay. I'll pass the witness, Your Honor.
Nothing further, Your Honor.
Okay, any other witnesses?
Rest.
Mr.
No,
Cedillos?
we rest.
All right, and Mr. Nichols, what exactly are you asking for?
Your Honor.
I mean, you flashed up some stuff on the screen, but.
Yes, so we're asking for a graduated possession and access schedule starting in May. That my client would have 10 a.m. to 6 p.m. with the child on the 1st, 3rd, and 5th weekends. That's without an overnight. And then the 4 to 7 on the intervening weeks. And then graduating to June, that same schedule, but an overnight on Saturday. That would be 2 overnights in June. And then starting basically standard 4 p.m. when the child, is 4 p.m. on Friday to 6 p.m. Sunday night, and those intervening weekends. So that's specific. Have I said that clearly enough, or do you want me to go back over it? I'm sorry, Judge. I might have gone through too quickly.
What month is on this calendar right now?
This is July.
Okay.
July would be what we're hoping to get to as soon as possible with the full weekend overnights. June would include just 1 overnight on the weekend, which would equate to only 2 times in June. And then May, we're just asking for basically the weekend days, 10 a.m. to 6, but no overnights in the month of May. So that's what we are requesting.
All right. Mr. Cedios? I actually, and I didn't, what exactly are you asking for? And this is not just argument. You can have something more in the moment. I just want to know exactly what you're asking for.
Yeah, can you hear me, Judge?
Yes.
Yeah, we're asking for 4 hours on the on weekends, at least for the first month, and then 2 hours during the week, Tuesday and Thursday, as long as the child is home by 7. And I didn't provide testimony about this, but after 5:30, if the child is in daycare, then they start charging them, I think, $1 a minute. So Mr. Foster can pick up the child during the week as long as he can do it by 5:30, before 5:30. We're asking that for, graduated possession and access, at least for May, and then increase it a little bit in June and July and August, September. But we're not asking, Ms. Munoz is genuinely concerned about the overnight visitation, Your Honor, overnights with her son. So that's what we're asking for.
Okay, and do you have any agreement about app close or some other electronic means of?
It would probably be helpful for them to do it, Judge, app close, so that they're not spending the money on our Family Wizard.
Yeah, I think that would be helpful. It's a free app.
Okay. All right. Argument, Mr. Nichols, or is that everything?
It is, Judge. I mean, I just think that the idea of, I mean, there is absolutely no evidence that Mr. Foster poses any risk to his son. His ability to have a relationship with his son is not dependent on vague concerns. And certainly the idea, I mean, I think Ms. Munoz revealed her motivation that a father shouldn't have an overnight with her son until they're 4. I think Ms. Munoz wants to continue to be the gatekeeper and decide when Mr. Foster can and can't have a relationship, absent of finding a family violence, which there is no evidence of, or absent evidence that my client would injure or pose a risk to the safety and welfare of the child. The law requires that the court foster a robust relationship between parent and child. We don't have to ask for the graduated. We are, because we recognize that there has, and we can assign fault later on that, but there has been limited visitation, but there is no evidence why my client shouldn't have, as much time as possible. The notion that he hasn't tried to see his child. We're in court fighting to see his child, and Ms. Munoz still continues to deny him reasonable access that is outside of what she just unilaterally and arbitrarily determines is the best interest. As for the evidence on child support, the 17.5, the 530 would be the child support amount, 530. But if my client's going to be ordered to pay medical insurance, I think he testified that would be $200 divided by 2 children.
And I'm not, there was an objection to proceeding, and I'm not going to make decisions on child support today. If y'all can come to an agreement, that's great. We were just putting testimony on the record.
Okay, so that is, so then I won't argue about the child support today then. So that, as far as possession and access, we would request that the graduated schedule to July and the July schedule be what it is going forward until final.
All right, Mr. Cedios? Any other
Your Honor,
arguments?
of course, we're asking for graduated and no overnights. I think Ms. Munoz did testify. Well, I don't think, I mean, you did hear testimony about the situation with Avery, and Avery not spending the night until the child was 4. And during that time, Carla Munoz was a part of that relationship and able to help with Avery. So we're asking for a graduated step-up visitation, possession and access. Ms. Munoz does want to let Mr. Foster develop a relationship with his son. She's even willing to allow weekday visits. And with regard to the child support, Your Honor, I guess we'll have to set that for hearing in early May.
If the court feels it has adequate evidence, I'm fine with it. I'll withdraw the objection. The court can rule on that if Mr. Cedillos wants.
Okay, well, but we've released the AG, so if y'all have an agreed order, I mean, what is disputed?
Well, I'd have to look at that other cause number, Your Honor, and see what the child support was there,
Okay.
that's the issue I have.
If y'all are unable to get something agreed to, that's fine. Just get it set for hearing if you don't have an agreement to set it already.
Okay. But Your Honor, we're asking for a graduated step-up visitation, increasing every month, and they actually have to be actual visits. That's the important thing. It can be May, he exercised one, and then we go to a longer period in June. He exercised only one visitation, and we get longer visitation in July. They actually have to be visits that occur. That's all I have, Your Honor.
Okay. All right, I'll order two different things. One is from, 4 to 7 on Thursdays. And I understand that that's going to be picking up from daycare.
Yes.
And I understand that it may be a few minutes after, before Mr. Foster can get there. And on the first, third, and fifth Saturdays, I will order 4 hours, and I'll let the attorneys confer and see if you can agree on when it'll start, but 4 hours in May, 6 in June, 8 in July. And then in August, we'll add 1 overnight. September through December, 2 overnights a month. That can be either Friday or Saturday night. And then January through whenever standard visitation kicks in, 1 overnight and 1 2-day weekend. And we'll add, of course, birthday and Father's Day possession, that 2 hours or whatever it is.
So, Your Honor, if I may ask just for clarification, when you say 1 overnight starting in August, do you mean each visitation or 1 overnight total?
1 overnight total. And that would be in lieu of the one of the Saturdays would become an overnight that's at Mr. Foster's.
Okay, so he would still get the 1st, 3rd, and 5th. It's just on one of those weekends in August, he can do an overnight.
Yes.
Okay, I got it.
Because I didn't hear anything that I thought overcame the presumption that you shouldn't have the standard until he's 3. And I didn't hear anything that overcame the presumption that he should have this, Mr. Foster should have the standard once the child is 3.
So I'm only, Your Honor. I'm
Mr.
only-
Foster, if you have anything, you direct that to your attorney. Okay.
And then you did 2 overnights in September through October, through the end of the year?
Yes, sir.
Okay.
And then some sort of possession on Christmas Day. Whatever, since they're not splitting the holiday. And I'll ask the attorneys to confer if you can't reach an agreement. I'll make a decision on that.
And on these hours, is it just the Saturday or Saturday and Sundays?
just the Saturday, and if y'all can make an agreement on when the hours will be, fine. If not, I'll come back and make a decision on that. I would hope that there'd be some flexibility there, and I will require that Mr. Foster exercise at least 2 of the Saturday possessions in a month before he proceeds to the next longer. So I'll agree with Mr. Cedillos that we're not going to have 1 4-hour possession in May, and then we're going to wait till August and say, okay, well, now we want our overnight. So if there's 3 Fridays, I'm not going to, or 3 weekends, he still is entitled to all 3, but I'm only going to say that in order to progress to the next month, he needs to have used at least 2 of those.
I understand. So when you say the overnights, Your Honor, is that?
I'm sorry. I'm sorry. At least 2 of the Saturday possessions.
Okay. So on the overnights, when they start in August and September, is it okay to say the 10 a.m. to 6 p.m. the next day?
I'll let y'all confer, the attorneys confer on all of those issues. If you can't make an agreement, just give me an order that has both of your requests, and I will check one of them.
All right. So starting in January, Your Honor, how many overnights are there a month?
1 overnight and one weekend, not an extended weekend, but just Friday night to Sunday night.
All right. Plus on the, but I'll still have the Saturday ones.
So he'll have 1 of each, unless he wants to drop that. If he wants, I'm not going to force him to do that, but that'd just be 2, but that'd be one Saturday, 1 overnight, and one Friday to Saturday. And again, I'll let you elect either Friday to Saturday or Saturday to Sunday.
Okay.
And I'll ask the attorneys to confer on how much notice through AppClose that Ms. Munoz is entitled to.
All right. And then January is just largely indefinite till final.
Yes, January would be the same until, I mean, standard possession would kick in on this when he turns 3.
All right. But all of these are just the Saturday, not the Sunday too, except the overnights.
Yes.
I don't have anything else for the court, Your Honor.
Okay, do you need a
Breakout room?
breakout room?
Yeah.
To discuss the rest of it? Okay, I'll ask Ms. Riley to do that.
Yeah, and I'll call my client, and I guess your client is there in your office, right, Mr. Nichols?
Yes.
Okay. I'll have to call my client.
All right.
But we do need a breakout room, yeah.
I just invited y'all to breakout room 3.
All right. And on the Brighton case,
Yes, Your Honor.
where do we stand?
I believe that the child is with the mother so that you can visit with the child.
Okay, and do I need to speak with the attorneys in a breakout room?
I would prefer, so yes.
All right, so let me see if I can. All right, I'm going to move both of y'all to room 5, and then I will join it.
Okay.
I'm going to join right now.
Mr. Cedillos, if you can go into breakout room 3. Ms. Hewlett, you got an invite to room 5, I believe.
All right, here come the attorneys. Ms. Cavazos, are you available?
Your Honor, I'm having my client, she was with the child and she didn't want to have the child listening to all this, so she's logging in right now, so she might be in the waiting room. And then she'll step outside so the daughter can speak
All
with
right.
you.
Now there's an Emmy Brighton online right now.
That's the petitioner.
Okay,
That's my client, Your Honor. That's Michael Brighton.
okay.
And Judge Wilson, I just wanted to give you a heads up. I'm gonna have to log off at noon, but if you're still on, after 1, I'll check back with you.
Okay.
And Your Honor, there is just one other issue that was in the Rule 11 agreement that opposing counsel was aware. I had a hearing and come out at 1:30, and we had agreed to be done by 1:15.
Oh, yeah, no, we'll be done by well before then. You know, Michelle has just logged in. Is that?
That is my client, and there's the child.
Okay, so I'm gonna send that phone an invitation to a breakout room, and I'm going to send Ms. Cavazos the same one. And Ms. Brighton, I'll ask you or your daughter to accept the invitation to a breakout room when it comes in just a moment.
And can you ask the mother to step out of the car, Your Honor?
Yes, I will be
Oh, and
stepping
yes,
out.
please, absolutely. Okay, everyone's gotten an invitation to breakout room 7. All right. Okay, and did Aspen just go back into?
Yes, sir.
Walk back in? Oh, okay, all right, that's fine. All right,
Do
so.
do you still need her?
No, no, no. I didn't know if you had to check her back in or.
Oh, no, she can go in on her own.
Okay, okay. All right, I've had a chance to speak to her. For the temporary orders, do the parties want to call any witnesses?
Yes, Your Honor, and I would also like to, on the record, make some of the, an opening statement and the motion for continuance that was, or the not ready. I don't know if that was on the record for this cause number.
I believe so, but I'll let you put it on. All right. And Ms. Lopez?
Yes.
All right, you ready to proceed?
Yes.
Actually, your motion, I guess. So let me let Ms. Hewlett get her not ready. Go ahead, ma'am. I'm just not ready, Ms. Hewlett.
Yes. I was hired on this matter on the 16th, which was a Friday, prior to even speaking with my client. I reached out to Ms. Lopez to let her know that I had a prior vacation on letter for the following week and wouldn't be able to attend. Since Ms. Stone has hired me, I have been on vacation for part of that time. And unfortunately, Ms. Stone's grandmother passed away and there was a funeral yesterday, so she was unavailable to prepare as well. So we had asked the court for a continuance for 1 week in order to have the subpoenaed witnesses of the therapist, both Sherry Key, the CPS worker. We are in the process of obtaining the criminal records from Guadalupe County, and and Robin Brown, who spoke to the child recently about her concerns and issues. We are asking there is a mandatory transfer to this case, and we understand that the court has authority to make temporary orders until then. However, we are asking that we at least be given the opportunity to subpoena the witnesses, considering the temporary orders are regarding the safety and welfare of the child, and these professionals, I believe, would offer a great deal of guidance in the court regarding the child's mental state at this point, and ways that the parents and the court can make rulings that could help the child and hopefully be in a better place after the summer break. So we had asked for we had announced not ready on this motion for temporary orders.
Your Honor, my response to that is that we filed our motion to modify on March the 29th, and we served accordingly. We gave plenty of notice for a hearing on the 22nd of April. I received 2 phone calls on April the 16th from Carolyn Hewlett, who said that she knew about the case being set on the 22nd, and even though she knew that she was not available, she decided to go ahead and be hired by Ms. Stone rather than telling her, I'm sorry, I'm not available, and passing on that case. So when she called me, I graciously said I do not interfere with people's vacation letters. So we agreed to a reset. I gave her the dates of the 28th and the 29th. I told her because the child is very unhappy where she's living and she wants to move with her dad, I cannot go past a week reset. So she and I verbally had agreed to the 28th, knowing that she needed to be out of here by 1:15 for her 1:30 hearing. We then had some mix-up between legal assistants, and I was very set on no. We verbally agreed to the 28th. I want to stick with that date. So we entered into a Rule 11 that was prepared by Carolyn Hewlett's firm, and we filed that on 4/21, where we both agreed to the 28th today at 9 a.m. We had already filed our motion to confer with the child. We did that on the same date as the motion to modify on 3/29. They then filed on 4/26, 5 days after the Rule 11, so they already knew what date we were agreeing to. On 4/26, they filed a respondent's original answer, and they filed a motion to transfer. They never filed a counter petition to ask for any affirmative relief, so today they have nothing on file, and under the rules of civil procedure, they cannot be granted anything because they have not asked for anything. They also did not file a motion for continuance. That has to be filed 3 days before. And I just don't see that it's very professional when you agree to a certain date and you sign a Rule 11 that's enforceable, that you then turn around and ask for a not ready and ask for a continuance when you didn't even file the paperwork. So I respectfully ask this court to deny the not ready because we all knew we were supposed to be ready for today, and she already had 1 extra week to prepare. So we ask this court to deny the not ready.
May I?
No, we need to get going. And I've heard most of these arguments before. I will deny the not ready. Again, this is just on temporary orders, and because it's being transferred to Guadalupe County, it may be several weeks before anything else can take place. All right, and Mr. Nichols, I'm going to sign those orders and I'll post those to Ms.
Oh, yes.
Is there something?
Yes, sir.
Or does that need to be incorporated into a regular order before?
No, it is. It needs to be incorporated. I just wanted to, I think Mr. Cedios is back. That was the order that we got through September. And I think you ordered anyway that the September schedule would continue throughout the end of the year. So we just want that. And so if there's a dispute on the entry of the actual temporary orders that we have, that's the schedule the parties have agreed to. So that's all I'm coming back for. I posted that handwritten schedule in chat.
And I've just pulled it up. All right, Mr. Cedillo, you're in agreement with just that that's the form that you've agreed to?
Yes, Your Honor. And just to let Mr. Nichols know, my client's informed me that he can start visitation this Thursday.
Oh, okay, yeah. This Thursday, yes. Okay, sounds good.
This Thursday.
Okay,
And then,
all right. So y'all are
we're good with everything else.
okay. Y'all are excused, and if you need to take off.
Thank you. Have a good day.
Thank you, Your Honor. I may have the name change. My client's here.
Well, we're going to do this other case first.
Okay, that's fine.
Okay. All right. Your first witness, Ms. Lopez.
Michael Brighton, Your Honor.
And have the parties been sworn in?
No, Your Honor.
All right. And Michelle's last name is?
Stone.
All right. I'm going to ask Michael Brighton and Michelle Stone to raise their right hands. Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes.
Okay. All right. And we typically have a 1 hour cap on temporary orders. We've used a lot of that up, but I will let both sides have 25 minutes so that'll get us pretty close to the 115 if you use all of that. Go ahead, Ms. Lopez.
Thank you, Your Honor. Please state your name, Mr. Brighton, for the record.
Michael Edward Brighton, Jr.
And were you previously married to Michelle Moore Brighton Stone?
That is correct.
And did y'all get divorced July 28th of 2015?
Yes, ma'am.
And in that divorce, did y'all have one child of the marriage?
Yes, ma'am.
Is that child a female child, Aspen Cole Brighton, born on December 20th, 2005?
Yes, ma'am.
And in that final agreed decree of divorce, did it set out that Michelle had the exclusive right to designate the primary residence of the child?
Yes, ma'am.
And did you file recently a motion to modify the parent-child relationship to modify that portion of the final decree?
Yes, ma'am.
And did you find something that was unworkable in that divorce decree or something that had changed that was the reason for the modification request?
My daughter came to me and told me that she was unhappy with her situation living at home and she wanted to come live with me.
And how old is Aspen at this time?
She is 15 years old.
And where does she go to school?
Lavernia ISD.
And what grade is she in?
She's a freshman.
And under the agreed decree of divorce, do you have the standard possession order?
Yes, ma'am.
And have you been diligently and duly exercising that standard possession order?
Yes, ma'am.
Do you remember or approximately remember what date Aspen came to you and asked you to file this motion?
It happened somewhere around early April.
We filed it on March the 29th. So to refresh your memory, we filed it 3/29/21. So can you?
It was the end of February. It was a couple weeks before we filed.
Okay, so end of February then?
Yes, ma'am.
And how did she approach you?
She told me that she wanted to live with me and that every time that I take her home, she always gets depressed and stuff. And she always tells me, I don't want to go home.
And have you seen a change in her behavior recently?
It's changed a little bit. Her grades have dropped, and we've been working on that, trying to get those back up. And she just seems happy over here. And then whenever I have to take her home, she seems sad.
All right. You heard in the statement of the opposing counsel when she was asking for a motion for continuance that they were in fear of the safety and welfare of the child. I wrote that down, that there was an issue of safety and welfare of the child. Did you file this because you thought at all that your daughter was in some kind of danger?
No, ma'am.
And did you think at all that there was any kind of medical neglect by Michelle?
No, ma'am.
And you didn't allege anything about the dangers of your child, did you?
No, ma'am.
Was this solely done at the request of your daughter?
Yes, ma'am.
But for your daughter coming to you and asking you this, would you have filed this motion to modify?
No, ma'am.
So based on your daughter's wishes, do you believe it is in the best interest to have her move into your house?
Yes, ma'am, I believe so.
And please give the court your reasoning of why you think it's in the best interest that you honor the wishes of your daughter to move her to you.
I think she'd be happier, and I believe that her grades would go up and she would progress better in school.
When you mentioned to the court that her behavior changes when you go to drop her off. Where do you pick up the child when your periods of possession begin?
I pick her up from school, or my in-laws pick her up from school.
And then when do you take her back?
When I have possession, I take her home on Sunday nights at 6.
And please explain to this court what you witness in her mood on Sundays when you take her back.
Normally a couple hours before we get ready to pack everything up, she starts moping around and being sad, and she just doesn't want to leave.
And how long has that been going on?
For about 2 or 3 months.
Does that correlate with the time period that her grades started going down?
Yes, ma'am.
And how do you check on her grades?
I check her grades through the website, Parent Ascender.
So do you stay pretty well informed through that portal?
Yes, ma'am.
And what did you do when you noticed that her grades were slipping?
I got with her and we went through and looked at her grades and asked her, okay, well, this is missing, this is missing. Do you know where they're at? She goes, I believe those are in my backpack. She went and got them and said, okay, now you need to turn them in tomorrow. And she turned them in.
All right, so she had done them, she just was not turning them in from her backpack?
That's correct.
Okay. Were you helping her personally at your house when you had her to help her bring up these grades?
Yes, ma'am. Whenever she has homework, I help her with anything that she has.
All right. With regards to safety and welfare, was it shocking to you to hear the opposing attorney say that there were some issues that concerned safety right now?
Yes, ma'am.
Is there anything that you see is a danger or something where your child is having welfare concerns?
No, ma'am.
Had there been some in the past?
Yes.
Okay, and what were they in the past?
There was a case where my daughter and my oldest stepson from my new marriage, they, according to the file, they had consensual sex.
And on this CPS case, where was it based? What county?
Guadalupe County.
And what year was it?
That was 2018.
And how old was Aspen at that time?
She was 13.
And how old was the boy?
14 or 15.
And has that case been closed?
Yes, ma'am.
Do you recall, did you receive a letter from them telling you that it had been closed?
Yes, ma'am.
Do you recall what the findings were?
There was no evidence found and everything was found to be consensual.
Did you force your daughter to say any certain type of testimony in that case to any of the investigators?
No, ma'am.
Did you ever even talk to her about that case?
No, ma'am, I did not. Besides the conversation that her mother and I had on her front porch when they brought it to my attention that it had happened.
So you only talked to Michelle about it?
Yes, ma'am.
And never once did you try to influence testimony of anybody in that case?
No, ma'am.
Have there been any other cases filed since that one?
No, ma'am.
So if I told you that opposing counsel represented to the court that there was an open case right now in Guadalupe County with indecency with a child, would that be false?
I have no recollection of it.
Okay. So at this time, you know of no other open cases?
That is correct.
And the indecency with the child, wasn't that the 2018 CPS case?
Yes, ma'am, I believe so.
Have you ever known of your daughter to recently be sending any type of inappropriate pictures to Doc, your oldest stepson?
No, ma'am.
Had she ever done that in the past?
Yes, ma'am, she had.
Was that part of the 2018 CPS case?
Yes, ma'am.
So there's nothing recency with indecency or Snapchat pictures. Is that correct?
That is correct.
All of that was wrapped up and y'all handled that previously?
Yes, ma'am.
With regards to a safety plan, in that 2018 case, was there a safety plan?
Yes, ma'am.
And what was that safety plan?
To not leave the two kids alone together unattended.
Did y'all continue that safety plan even after the 2018 case had been closed?
Yes, ma'am, that is correct.
So is it your testimony to the court that since 2018 case came about with these allegations, that once the safety plan was put into place, to the best of your knowledge and your new wife Emily's knowledge, the kids have never been left alone?
The only time they've been left alone is whenever my son has brought my daughter home from school one or two times. That's it. And he had left to go to work.
Okay, and where does he work?
He was working at Taco Bell at that time, but now he's working for a landscape company.
For who?
A landscape company?
All right, and does he live at your house anymore?
No, ma'am.
With regards to talking about cases, have you talked to your daughter about this particular case at hand?
Yes, ma'am, I have.
And why have you been doing that?
Because she was asking how everything was going.
And is that based on her asking you to start this case?
Yes, ma'am.
Has she asked you to keep her informed about when she's going to be talking to the judge?
I have been giving her regular updates, yes.
Okay. And are you, in those updates, are you just giving her procedural updates about timing and dates, or are you coaxing her and coaching her on testimony?
Just dates and times.
So if we were to look at those text messages, there would not be anything about you telling her, say this to the judge, or say that to the judge, or say this to your mom, or say that to your mom?
That is correct.
Do you have a drinking problem?
No, ma'am, I do not.
Have you ever been arrested for a felony DWI?
No, ma'am, I have not.
Do you have knowledge that the mother of the child, Michelle, has a DWI conviction felony?
Yes, ma'am, I am.
And was that felony conviction due to her drinking and driving while she had Aspen in the car with her?
Yes, ma'am.
And was she put on probation for that?
Yes, ma'am.
Did she have to have an interlock on her vehicle for that?
Yes, ma'am.
And to the best of your knowledge, do you know if she successfully completed her probation?
As far as I know, she has.
But even when that happened, you did not strike that. Does Aspen have a boyfriend at this time?
Yes, ma'am.
Do you have rules in place between her and the boyfriend?
Yes, ma'am.
And what are those rules?
No inappropriate pictures, no inappropriate touching, no inappropriate anything. And sometimes I have to get on her about getting off her phone, talking to him.
What is the boyfriend's name?
Name is Lane.
Do you know how old he is?
I believe he's 15 also.
And do you have rules about Lane when he comes to your home?
He has never come to my house.
How do you enforce the rules between you and your daughter with regards to the boyfriend?
I tell her to get off the phone and I wait there until she gets off the phone.
And what time is your cutoff time for her to get off the phone?
Usually about 10 or 10:30.
If somebody states that you allow her to FaceTime and talk on the phone till 4 a.m., would you find that to be true or false?
I find that to be false.
Have you ever caught her past 10:30 sneaking a phone call or a FaceTime with her boyfriend?
No, ma'am.
And who is in charge of the cell phone payment?
I am.
And who gets the records for the phone?
I do.
Has her mother ever seen those cell phone records?
No, ma'am.
So if she told her attorney that she's seen the records, would that be true or false?
That would be false.
Has she ever asked you to see the phone records?
No, ma'am.
Has she ever subpoenaed the phone records?
No, ma'am.
Has the mother ever, do y'all do app close with one another or do you just text?
Just text.
Do you think that, have you heard that we've agreed today that y'all will go to an app close application on your phone to do all of your communications?
No, I have not.
Okay. If the court so orders it, will you adhere to communicating through the app close application unless in case of emergency?
Yes, ma'am.
With text messages between how do y'all communicate?
Through text messages.
Is that the only way?
Yes, ma'am.
Do y'all communicate about your child's phone usage?
No, ma'am.
Has the mom ever complained to you that she doesn't like the rules in your house about the telephone?
No, ma'am.
Has she ever asked you what your rules are?
No, ma'am.
Has she ever asked you if you have caught the daughter after 10:30 using the phone?
No, ma'am.
So do you know how she would have information at all of the child allegedly speaking to the boy in the middle of the night on the phone?
No, ma'am.
Is there anything, let me ask you this. When was the last time your child went to counseling?
This past Saturday.
Before that, when was the last time?
June of 2020.
And who was her therapist at that time?
I don't know her name.
And so from June of 2020 until now, did you know that she was not in counseling?
No, I didn't know she was not in counseling.
Okay. Did the mother communicate to you that she was going to start up counseling this past Saturday?
No, ma'am.
Isn't it true that in your divorce decree on page 2 that you have the right to receive information from the other conservator regarding health, education, and welfare of the child?
Yes, ma'am.
Did you receive any information from Michelle prior to this Saturday appointment for counseling?
No, ma'am.
Are you aware that on page 3 of your decree, it says that Michelle has the duty to inform you in a timely manner of significant information concerning health, education, and welfare of the child? Are you familiar with that?
Yes, ma'am.
Did Michelle adhere to that and give you significant information in a timely manner that she was taking the child to counseling this last Saturday?
No, ma'am.
How did you find out that the child went to counseling on Saturday?
My daughter told me last night.
Did the daughter know it, or was it a surprise to her that she was going?
It was kind of a surprise. Her mom told her you're going.
And the child did not ask to go resume counseling?
Not that I'm aware of.
Did you see any need that the child needed to go back to counseling?
No, ma'am.
If the court orders the child to go to counseling, will you adhere to that order and take the child to counseling?
Yes, ma'am.
Letters to dad. Did your daughter write you letters at any time?
Yes, ma'am.
And when was the last letter that she wrote to you?
The last letter was April of 2020.
And what was the gist of those letters that she wrote to you?
That she was upset with me that I was not spending enough time with her, that I was putting the other family boys in front of her needs.
Did y'all communicate about how to handle that issue?
Yes, ma'am.
How did y'all resolve her concerns?
We talked about it and we started spending more time together. I've helped her quite a bit with practicing her softball techniques and working on her batting and throwing. And we started watching movies together here and there at the house when she's here with me.
So have y'all started doing some more daddy-daughter things as a result of how she was feeling?
Yes, ma'am.
To the best of your knowledge, has the concerns that she had that she was writing to you, have those been addressed and handled?
Yes, ma'am.
And do you believe that everybody is in a good place for her to come and live with you?
Yes, ma'am.
Will she have a room of her own when she comes to live with you?
Yes, ma'am.
Is there anything that you would like this court to know that I have not asked you?
No, ma'am.
Okay, pass the witness, Your Honor. And can you please give me my time?
Okay. You've got 7 minutes left.
All right. Thank you, Your Honor. I'll pass the witness.
Go ahead, ma'am.
Earlier, I heard you refer to the CPS incident in 2018 as consensual sex. Is that how you classify that incident?
I believe that's what the report said.
Okay. And at that time, your stepson, Doc, was a freshman in high school?
Yes, ma'am.
And your daughter was a sixth grader?
Yes, ma'am.
And you believe that that was consensual sex?
I never questioned it and I never asked about it.
It doesn't concern you that
Yes, it
your
does.
daughter. Okay, what steps did you take prior to CPS putting a safety plan in place to protect your daughter?
Before the safety plan was in place, me and my wife separated and she took her 2 boys with her and lived with her mom, and it was just me and Aspen at our house.
That was after the safety plan was in place, correct?
No, ma'am, that was when it started happening, when we found out about it, I believe.
Have you ever blamed Aspen for your separation with your wife while drunk?
No, ma'am.
Would it surprise you if she told a therapist that that happened?
I have no idea what she told the therapist.
So after your daughter was assaulted, she was in therapy from...
Objection to the word assaulted, Your Honor.
All right, I'll overrule the objection. I understand there's a dispute, but this is temporary orders. All right, go ahead, sir, ma'am.
How long was your daughter in therapy after that incident?
I believe all the way until June of 2020. This is as far back as I can go on my records to find out.
Okay. And you were aware of this?
I was aware of it at the time, yes.
And what's the therapist's name?
I have no idea.
How many times did you participate in therapy with your daughter?
None.
Why not?
I was never asked to.
Did you read your daughter's CPS statement?
No, ma'am, I have not.
Why did you not read it?
I don't know. I just probably didn't read it.
Is it your understanding that your daughter said she did not consent?
No.
Where is Doc currently living?
4 or 5 streets over from here.
When did he move out?
Last weekend or the weekend prior.
Why did he move out?
He graduated high school and him and his buddy got a place together.
After the sexual assault, how many bedrooms did you have at your house?
4 bedrooms.
Did you and your wife move into a 3-bedroom home?
Yes, ma'am.
Who had the bedrooms?
The 2 boys.
Why didn't your daughter have a bedroom?
Because we were planning on getting the oldest boy out into his own room outside of on the property, but inside of another building. And we were in the process of making all that happen, and Aspen did not have a room for some time.
For over a year.
I'd say about 8 months, 9 months.
Isn't that one of the issues that your daughter wrote you about in 2020?
Yes, ma'am, that was.
And when Doc would be on the property, he would still be using the kitchen and the bathroom.
Yes, ma'am.
Did you have any safety precautions or safety plans in place to make sure that there was no sexual activity between Doc and Aspen?
No, I was usually here whenever everybody was home.
What are your work hours?
I work 4 10-hour days.
4 10-hour days?
Yes,
What
ma'am.
days?
6 to 4:30, Monday through Thursday.
And do you work overtime?
There have been times I have worked overtime, yes.
Has your daughter expressed to you that she feels you work too much?
No, ma'am.
She didn't say that in any of her letters.
She may have, but I don't remember all of them.
So it was multiple letters.
There's been a couple, yes.
Do you check Aspen's phone?
Not all the time.
Earlier, you testified that there were inappropriate sexual pictures being sent. Why would you not check her phone?
Because at that time that happened, the Snapchat app was deleted, and then I was going through her phone all the time. And then I stopped.
Do you know if Aspen is sexually active right now?
No, ma'am, I do not.
Have you talked to her about that?
No, ma'am, I have not.
Have you allowed her to be at her boyfriend's house unsupervised?
No, ma'am, I have not.
Do you have any apps on her phone that show where she is?
Yes, ma'am.
So if you were to look on that phone, you would know if she was at her boyfriend's house.
Yes, ma'am, that is correct.
Why is it that you wouldn't attend activities like band?
Do what?
Why would you not attend her extracurricular activities such as band?
I have, all except for a few, because it was at a football game and the tickets were sold out to the game, but I watched the halftime performance on the TSP app that live streams the football game.
Since filing this case, you discussed this matter with your daughter.
Yes, I have. I have asked her several times if this is truly what she wants to do.
Have you asked her if her mother had been served?
Yes, ma'am, I have.
did you ask her if her mother was upset?
Yes, I did.
Did you tell her that you thought her mother would be upset once she got served?
I would assume she would have been. But yes, I did ask her.
Do you think it's appropriate to tell a 15-year-old to discuss these kind of matters with her?
She asked and I was telling her.
Did you read the petition that you filed?
Yes, ma'am.
Earlier, you testified that you had no safety concerns. There's no issues with safety or welfare of the child.
That's correct.
Why is your pleading so your pleading is asking for temporary orders based on the safety and welfare of the child?
That way, because my daughter would be more happier here.
But there's no safety or welfare concerns.
Wouldn't the welfare part be part of the emotional part?
Well, I'm just clarifying your testimony because earlier you said there were no safety or welfare concerns of the child.
So that's correct.
Are you changing your testimony now?
No, ma'am. I don't feel there's any safety concerns.
You do not feel there's any safety concerns. What is the urgency in having temporary orders change primary at this point if you have no safety or welfare concerns?
It was my daughter's wishes, so I followed up on them.
You testified that your ex-wife would not have any knowledge about phone messages on your daughter's phone. Is that correct?
That is correct, unless she has gone through her phone.
Do you think it's appropriate for a parent to check a 15-year-old child's phone when there's been acts of sexual inappropriate text messages?
No, ma'am.
No, you think that's okay?
No, it's not okay.
It's not okay to check the child's phone.
Yes, it's okay to check the child's phone. Yes. Sorry, I misunderstood you.
So you don't check the phone personally. You count on Michelle to do that parenting.
Objection, asked and answered, assuming facts not in evidence. She asked him and he testified he does check her phone, but not all the time.
All right, I'll sustain the objection. You can rephrase that if you wish.
When was the last time you checked your phone?
Probably about a month ago.
You testified that your daughter's grades had started to decline, correct?
Yes, ma'am.
What grades?
English and biology.
What are her teachers' names?
Her English teacher is Miss Morrison, and I don't know off the top of my head what her biology teacher's name is.
Have you had any communication with them?
No, ma'am, I have not.
Do you agree that Michelle is the parent who primarily communicates with the teachers?
I have no idea if she communicates with the teachers or not.
Do you agree that Michelle is the parent who takes your daughter to the doctor?
Yes, ma'am.
Is there, you had said that your stepson Dax had moved out about a week ago. Is there any reason his truck would be at your house several times in the last week?
He was coming over getting the rest of his stuff, and he came over the other night. He's come over a couple times during the night to talk to us.
After the safety plan ended in 2018, that following month, did you take your daughter and Doc on a camping trip?
We took the entire family on a camping trip.
Do you think that's appropriate to do to a young child who has just had a sexual encounter with a stepbrother?
We were just trying to get away and let everything let go.
Do you feel that you addressed the issue appropriately?
Yes, ma'am.
Do you feel that you swept the issue under the rug?
Some of it.
Do you think that's healthy for Aspen?
No, ma'am.
And do you agree that Michelle is actively involved in Aspen's life?
Yes, I do.
And do you think Michelle's a good mother?
Yes, I do.
What aspects do you think make Michelle a good mother?
She's caring and she's on top of everything with Aspen, and I'm not always because she's not here all the time, but she's always there for her.
And your decree states that you have from 6 to 8 on Tuesdays, correct?
That is correct.
Didn't Michelle voluntarily allow you to have from after school?
Yes, ma'am.
So she's worked with you to try to get you more time to build up that relationship with Aspen.
Yes, ma'am.
Do you believe that your actions in 2020 hurt your daughter?
Objection, Your Honor. That's not 2020 was 12 months long. She said actions.
I'll sustain the objection.
Did you exercise your possession in March and April of 2020?
Yes, ma'am.
Every time?
No, ma'am. That was when the COVID was being real bad, and my wife is a nurse and she had gotten tested, and my youngest son had gotten tested because they were around it. And there was a couple of times that I did not take possession of Aspen because of safety concerns.
On April 2nd of 2020, did she send you a picture with a letter addressing all of the concerns she had with your relationship?
Believe so. Maybe it was April 18th of 2020.
And you did not reply to her until after Mother's Day. Why not?
Because I was taking time to think about everything that I wanted to say to her.
Do you think that hurt her to be ignored like that by her father?
Probably.
And who was the parent who was there comforting her during that time?
That would be Michelle.
Sorry, 1 second, Your Honor. And about 2 months ago, when the decline in grades started, did you come to find out about your daughter having Snapchat on her phone?
Yes.
Did you tell Michelle about this?
No, ma'am, I did not.
Do you think when a child who has experienced a sexual experience extremely young is sexually acting out, do you think that's something you should tell the other parent?
Objection, Your Honor. Snapchat is not correlated to sex at this point. Assuming facts not in evidence. She has no proof of what the Snapchat has been used for.
Okay, I'll sustain the objection.
Did your daughter send sexually explicit Snapchats?
Yes, she did.
Objection, Your Honor. Asked and answered. It was part of the 2018 CPS case that is closed.
Mr. Bratton, did
Okay,
you?
overruled. Go ahead. All right, so just so I'm clarify, has there been any more recent than 2018 Snapchat transmissions of that sort?
No, sir, not that I'm aware of. No, sir.
All right, go ahead, Ms. Hewlett.
And by and just to clarify, are you referring to no sexually typed Snapchats or text messages to just Doc, or both to Doc and her boyfriend?
Just to Doc. or her boyfriend. I haven't seen anything like that to her boyfriend.
And do you take your daughter's phone away from her at night?
No, ma'am, I do not.
So it's possible that she is texting her boyfriend till 4 o'clock in the morning.
Yes, ma'am, it is very possible.
Have you seen these phone calls and text messages?
No, ma'am, I have not.
Have you made derogatory comments about Michelle's current husband?
No, ma'am, I have not.
Do you think that your relationship with Michelle, the communication needs to improve?
Yes, I do.
What steps are you willing to take to improve that relationship?
I guess just to ask her more about what's going on with her, with Aspen while she's not with me.
And the last question I have for you is, in your petition for these temporary orders, the HIPAA release, the medical, the notification, all of these requests are things that you currently have in your current order, correct?
I believe so.
So there's nothing stopping you from taking your daughter to the doctor,
No, ma'am.
and there's nothing stopping you from communicating with her therapist.
I guess.
And in April of 2020, when you were not speaking to her, were you aware that your daughter had the flu and strep throat?
Yes, ma'am, that is correct.
And were you aware that she was very upset that you didn't call to check in on her?
Yes, ma'am, I was, but I did contact her mother and find out how she was doing.
And it's your testimony that you have never left Aspen alone with Doc since the 2018 assault, other than 2 times that he took her home from school.
I believe so.
You've got 5 minutes left, Ms. Hewlett.
No further questions.
Anything else for this witness?
No, Your Honor.
All right, your next witness.
None, Your Honor. I rest.
All right, Ms. Hewlett. All
I call my client, Michelle Stone.
right, go ahead.
Michelle, have you noticed any differences in your daughter in the past few months?
Yes.
Please, can you tell me what those changes are?
Her grades have declined. Her lack of interest in school has declined. She tends to be very emotional. She's very roller coaster of emotions. Sometimes she's happy, sometimes she's sad, sometimes she's angry. Other than that, I mean, I know she is staying up late, and there are times where she isn't getting proper sleep. So I know in the mornings when I ask her, are you okay? Are you tired? And she'll say yes. But mostly, yes, I have seen a decline.
And who is the person who, or do you communicate with her teachers regarding her grades?
I do.
To your knowledge, has Mr. Brighton communicated with the teachers regarding her grades?
I'm unaware.
The days that she doesn't turn in homework, are those days typically days that are with the dad, or when she's with you?
They vary. It a lot of times has been because she was playing softball and she was missing classes. She was getting taken out early. So it would vary if it was between my time or his time.
Do you feel, have you and your daughter talked about the 2018 incident?
Yes, ma'am.
To your knowledge, was that 2018 incident consensual?
To my knowledge, it was not.
To your knowledge, has Mr. Brighton ever talked to Aspen about that incident?
Objection, speculation, hearsay.
I asked to her knowledge.
To my knowledge,
I'll
no.
rule the objection.
Are you, I think she's frozen.
Oh, I'm sorry. Do I answer? I was confused.
Yes, you may answer.
Okay, to my knowledge, no, he has not.
To your knowledge, has your daughter been alone with Doc since that incident?
Yes. At least I know in his vehicle. As far as any other times, I'm not 100% sure.
Are you and your daughter currently working on bettering your relationship?
Yes.
What do you think, in your opinion, what has caused the friction in your relationship?
I believe since she got a boyfriend, she doesn't agree with the rules that I have. And of course, as any teenager, they are going to be a little rebellious. But I do feel like things have changed ever since the boyfriend came into the picture. They do talk a lot, and I do have rules at my home that are set in place. Before this was brought to my attention with paperwork being served, she did not have her phone in her room at night. I would keep it in my room. And since then, she and I have talked about things because I feel that maybe I did need to give her a little bit of leeway and freedom. So I have given her a 10 o'clock cutoff. The phone does stay in her room. But since that has happened, she has continued to be on the phone with her boyfriend. I have seen text messages between her and her boyfriend that he's checking to see if I'm still awake. Seeing at after 11 o'clock, 11:30, there's conversations going on. There are phone calls being made. So I have since not allowed all of that to happen. But that is, I feel like a lot of it is because I do have rules in place and she just now does not agree with my rules.
To your knowledge, is Aspen allowed to drink at her father's house?
No, and not to my knowledge.
Do you feel that Aspen would be adequately supervised if she were to stay with her father?
I have concerns.
Can you tell the court what those concerns are?
I do have concerns that there are phone calls, FaceTimes being made, which I know can lead to inappropriate things. I do feel like my daughter had to grow up faster than she should have because of the incident in 2018. I know that her father and her have had a lot of up and down of their relationship. And I do feel like that has caused a lot of emotional stress on her. I think that it's caused some confusion sometimes. And I do have worries of her safety and what rules are actually in place over there.
And are you willing to take steps to improve the co-parenting relationship between you and your ex-husband?
Absolutely.
What steps do you want to take?
I would like to see us be able to communicate better. I would like my daughter not put in the middle so much of conversations. I do feel like we can communicate when we have taken the time to communicate. And I do feel like it is in her best interest that we communicate as her parents, meaning if that is rules of each house, if that's deadlines, for phone conversations to be cut off, limited time with her boyfriend. He now is 16 as of yesterday and will be driving by the end of this week. And I do have concerns about that. And she does know that I have rules in place at my house for when he is driving, and that it just will not be a come as you go kind of thing. And there will be curfews for both of them. But I do feel like we could communicate if we tried.
And you're willing to take those steps?
Absolutely.
Your Honor, I believe I'm out of time. So although I would have preferred to call the CPS worker and the child's therapist, I understand that we were limited to 1 hour.
All right, any argument? Or actually, I'm sorry, Ms. Lopez, did you have cross?
No, Your Honor. Well, let me just ask her one question, just a couple of questions about her DWI. Ms. Stone, were you arrested on 5/29 of 2016?
Yes, ma'am.
And was that in Aransas County?
Yes, ma'am.
And on the date that you were arrested, did you have the child in your car with you?
Yes, ma'am.
And were you indicted and found guilty of a felony DWI, endangerment to a child?
Yes, ma'am.
What was your level of intoxication on that day?
I do not remember.
Isn't
I
it
don't
true?
have the file with me.
Isn't it true that it was well over the 0.08 that is allowed?
Objection, she's already asked and answered. She does not remember.
I'll
Your Honor,
sustain
I'm
the
just
objection.
asking.
I'll sustain the objection.
And did you have to put an interlock device on your car?
Yes, ma'am.
How long did you have to have the interlock device on your car?
I don't remember the exact time frame.
And when were you discharged from your probation?
January 2017.
Isn't it true that it was January 31st of 2019 pursuant to the Texas State Criminal Records?
No, ma'am, it was not.
And what other arrest have you had?
I have not had any.
Relevancy.
Okay, I couldn't tell. Was there an objection?
Yeah, I'm sorry. Objection, relevancy. Mr. Brighton has already said that there are no safety concerns with the mother.
I can still ask about her history, Your Honor. They brought up
Okay,
drinking.
I'll overrule the objection, and she's already answered none. So your next question?
Okay, nothing further, Your Honor. I'll pass. I
Okay.
just reserve the rest of my time for an argument, Your Honor.
All right. Argument briefly.
Yes, Your Honor. Your Honor, this is a case, again, as I've said before, that the child is almost 16. She is the one who desires this. She came to her father, but for the child approaching her father and asking for this, we would not be here today. On either side, the 2018 case is in the past. It's been settled. I feel like Ms. Hewlett is trying to continue to slap this in the face of this child and not let her get over the past. It's in the past. It's done. And they have not resurrected it in any pleading since the divorce or since 2018. If Ms. Stone felt like this was still an issue, she would have brought something before the court. But the only time she's discussing it is in defense to her daughter wanting to leave. Other than that, nobody's talked about it. Maybe she's talked about it in therapy, but nobody's gone to CPS again. Nobody's gone to a criminal court ever, and nobody's come back to the civil court to change it. So the only reason that this case is being brought up today is because they have no other defense. This is a child who desires time with her dad. She has spent 15 and a half years with her mom. She has 3 years left of a high school education, and she wants to be with her dad. She wants to learn from her dad. She wants to share things with her dad. That's what she's been saying in her letters. I want to be with you. Now that she's over the age of 12, she finally gets a voice. She's been in therapy. Therapy has taught her, use your voice. She used her voice in the letters. She told her dad, I want a better relationship with you. They've been working on it. Even through COVID, they've gotten strong. They've got to the point where now she wants more of her dad. There's nothing wrong with wanting more of your dad. She's had her mom for 15 and a half years. Nobody is slamming her mom. Nobody is saying that she's a bad person. Nobody's saying that she's neglected it. My client has come and said she is a good mom. Nobody is saying she's a bad mom. Yet they come in their defense and they trash dad. Dad had no part in the 2018 CPS thing. He doesn't want to even think about somebody violating his daughter. I can understand why he wouldn't want to read a statement. That would be horrible for a dad to know what happened to his daughter. But yet he stood strong. He separated from his new wife. He went to a new place, just he and his daughter, until things could be worked out. He allowed the therapy. He allowed her to do what she needed to do to get better. He has even continued the safety plan since then. Nobody has brought this up until now, when somebody in a court proceeding needs to have some sort of defense. So I don't think it should be brought up now. I think the daughter should be encouraged in therapy if she needs it and she wants it. I think that they should come together and co-parent better. I think that they should talk about rules and make sure the rules are in the same house. But this is not a slamming dad and slamming mom case. This is a case about a child who desires to be with her dad, asked her dad to do this. The dad said, okay, I'll do it. I'm sure if the dad knew he was going to be thrown against the wall and tried to make look like a bad dad, he probably wouldn't have done this. But this is costing him time. This is costing him money. This is opening old wounds when all he's trying to do is to satisfy a desire that his daughter asked him to. The facts have shown today by both of these parents that the last 2 months, this girl has been slipping. The mother testified that there has been change in her daughter, that her daughter's grades have gone down, that she's been an emotional roller coaster, that she's lost interest in school, that she's staying up late and not getting sleep. Those things have happened in her home. That was her home. She's the one who said that she had to go wake her up in the morning because she stayed up late. That wasn't at dad's home. That was at mom's home. So we can see that if there's an emotional roller coaster and she's angry, that's at mom's home. There was no testimony that she was angry at dad at this point. The testimony was that she was sad and got depressed when she had to go back to mom's. So the changes in this case have happened in the last 2 months at mom's house. Everybody has seen it. Everybody is helping the child work on the grades, and dad is trying to help her be in a happy place. And right now, with everything that's going on with our teens and being in solidarity because of virtual school, dad is just trying to make sure that daughter is in a good place where she doesn't become one of these other statistics. So, Your Honor, our request today is that we do not look at the irrelevant stuff of 2018 that they're trying to flash in front of this court's face. That's done and over with. And if they had a problem with it, she would have brought something to you within the last 3 years, and the mother did not. It's because it's not a problem. The only issue is that daughter wants to come live with dad. So, Your Honor, we're asking today, based on our request and our petition, our motion to modify, is that this court today honor our request, and I will go down in my petition to hit each one of them. Ordering that the parties should remain joint managing conservators of the child. However, petitioner be named as the conservator who has the exclusive right to designate the primary residence of the child. Also ordering that petitioner be designated as the one who has the exclusive right to make decisions regarding the child's education. Ordering that his child support and medical obligations be terminated temporarily until final. Ordering that respondent have possession and access of the child pursuant to a standard possession order, and there would be no objection to an expanded standard possession order. Ordering that the respondent be ordered to pay guideline child support and reimburse petitioner for the health and dental insurance of the child. Ordering that each parent execute HIPAA releases so that the other party can be privy to the medical records. That was not set out exactly like that in the final decree. That's why I worded it that way in our request. Ordering that each parent list the other parent as a person to contact in case of emergency on all medical, school, community, church, and extracurricular activities. It was not written that way in the final decree. I got more specific in my request here. And ordering that each parent advise the other parent through the parenting application of any and all medical appointments so that each parent may attend said appointment. We're asking that app posts be ordered, and we're asking that the calendar and app posts be used so that all the appointments can be put on there. As the testimony showed, the child went back to a counselor this Saturday and nothing was communicated to the father as was ordered in the final decree of divorce. Thank you, Your Honor.
Your Honor, the fact that they're saying that the 2018 is done, is over, it's in the past. This is a 15-year-old girl who experienced non-consensual sexual contact at 6 years old. That is, it is a process that her dad has never dealt with.
Objection, Your Honor. Assuming facts not in evidence. There is no
All right,
CPS report.
I understand that that's what you have different opinions about what happened, and I'll keep that in mind. I'll rule the objection.
Thank you.
The child's preference is just one aspect. The father admits the primary parent has been Michelle. Michelle is the one who takes the child to the doctor to communicate with school, to set appropriate boundaries and discipline. She has been the primary caregiver. The issues, Mr. Brighton has admitted, it's not something that just happened recently. This was back in 2020. She was really struggling with her father being absent from her life. If you look at all of the Hawley factors, changing on temporary orders when the dad admits there is no concern of safety or welfare of the child. Currently, there would be if this child is put into a home in which a 17-year-old minor stepbrother who had, according to petitioner, consensual sex with a 6th grader, there would be a definite safety concern at that point. We both parties have agreed to use a child custody evaluator, Floyd Contreras, and we believe that these are issues that the court needs to hear from the CPS worker, from the therapist, to give the parties a chance to co-parent and get on the same page instead of allowing the child to do a splitting behavior in which she tells one parent one thing and the other. We're at the end of the school year and father is about to have his summer visitation. So there is really no urgent need right now. And mother has expressed her willingness to take steps to work with Mr. Brighton, but this is not a slam on Mr. Brighton as a father, but this is just the reality of a child who experienced this kind of trauma needs special care. And in this instance, she really does need her mother, even if she is acting out at this time. Her mother's the only one who was with her, with that counselor who supported her through all this and understood all of these aspects. So we think that removing the child from the mother's care would be detrimental and raise serious safety concerns regarding the child and the stepbrother. So we're asking to deny the relief on temporary orders, allow the child custody evaluator to evaluate each parent, and to have a full picture from all professionals before making such a drastic decision as changing a primary parent when it has been admitted that Michelle has been the primary parent for 15.5 years.
Okay, and Ms. Hewlett, it looks like we're making you late for your next meeting. You can blame it on the 2/18. I've listened to the evidence carefully. I'm not going to go any further with what I heard from Aspen than to say she's a very polite, well-spoken young woman. You're both to be congratulated on her. I think you're also, I think what is the primary concern, at least, is she expressed it, and what she considers to be the primary concern with the conflict has not been addressed by anyone. So y'all need to explore that with her and with her therapist. I will, for the time being, approve all of the approved changes, and I will. Has Mr. Brighton been using the expanded possession schedule or the regular? It sounds like the regular possession schedule.
It's a hybrid, Your Honor, because he will pick up after school on Fridays, but then he takes back to the mother's house at 6 o'clock on Sunday. So it's not the full expanded.
He does have every Thursday night and then Tuesdays from after school until 8 o'clock.
Okay. All right, so I will allow him, if he elects, to change that to the expanded standard, since they're both still in the same school district. And on the weeks when it's not in his period of possession during the summer, I will, since they're in the same school district, just a few minutes apart, allow them to go on week and week. And that would be in lieu of any weekend periods of possession. And I'll ask the attorneys to confer. I'll say that it'll start on a Friday at 6 p.m. since it's not during school, if y'all can't agree on something else.
Okay, I'm confused. You blanked out at the very beginning of your ruling. What was your ruling on conservatorship and who has the primary right to designate?
I'm going to leave that as it is, but I will allow Mr. Brighton, if he wishes, to expand to the extended periods of possession. So he would have her on the Sunday evenings, and I will place them once school is over with on weeks when he's not exercising his summer periods of possession. I'll put them on week and week. So it'll be 1 week with mom, 1 week with her with dad.
Okay, and
I'll give everybody a chance to see if that helps redress the issues. And I will also, and Ms. Lopez, your question?
Your Honor, right now in his final decree, he also gets the second and fourth Tuesdays of each month. So he gets, he's been doing overnight on Thursdays. So with the expanded, then that will go from school to school on Thursday. But since he also has the second and fourth Tuesdays, we would ask that that also be from school to school. It's
just for a month.
Right. So if we could,
We keep getting feedback from your side for some reason. I've muted you. I'll let you.
I would not like the court to take away his Tuesdays. He has to, on the second and fourth Tuesdays of each month during the regular school term, he has from 6 to 8 p.m. So if we're expanding all of his times, I would just ask that that one Tuesday in his off week be able to go from school to school as well.
I'll leave that at the 2 hours. So.
2 hours.
Okay.
And Your Honor, can we also have it that the agreements regarding the child custody evaluator made part of this order as well?
I will adopt all of that, and I will also adopt at temporary orders the requirement from the safety plan that Aspen not be alone with Doc. I don't know what the last name is. Her older stepbrother.
It's Martin.
Doc Martin, like the shoe.
I was just thinking that. Okay.
So Your Honor, just to clarify your ruling today, we're going to keep conservatorship the same for temporary orders. Mr. Brighton will have an expanded standard possession order. He will still have his Tuesdays from 6 to 8 on the second and fourth Tuesday. And beginning with the first Friday when school is out, he will have the first week of summer, and they will alternate summers until school begins again. And hopefully by that time we will be done with the CCE.
Well, I had said that was when it was not during the period of summer possession.
I'm sorry, say that again.
If Mr. Brighton wants the 30 days in the summer, I was not going to change that. I was just going to give him a more longer period of possession during the week, during the weeks when he did not have Aspen full-time in the summer.
Okay, so he still gets his 30 days from July 1 to July 31. And then during June and August, what was your ruling?
Week and week.
Week and week. Okay, so June
That
is
would be in
week to
lieu of
week.
anything else except Mother's Day or Father's Day.
All right, so he still gets his 30 days, and then for June and August for the summer, it's week to week.
And will mother get her designated periods expanded so she can go on vacation with her family as well?
Okay. You mean in July?
So she has the right to designate that one weekend that would.
Oh, yeah. That's unchanged. That's unchanged.
And then everything we've asked for, the HIPAA releases, the app close, everything else has been ordered by the court, including the app close and Floyd Contreras as the CCE.
Yeah, that's all in agreement, right?
It was all agreed to.
Okay, and again, somebody has feedback. I think it's Ms. Lopez. Okay, yes, all of that's agreed. So do you need an entry date?
Is Miss Lopez drafting?
Yes, I'm drafting. What is the entry date, Your Honor?
All right, Ms. Riley?
I don't know how much time they need, but your next dockets in Wilson County are going to be on May the 3rd, May 3rd, May 12th, May 18th. The 3rd would be an in-person, and so would be the 12th.
Okay.
I can shoot for May 18th.
My only concern would be it is a mandatory transfer of venue. And so if we could get this order entered before the 21 days is.
Okay, and when does the 21 days run?
Well, you can do your, well.
I guess if I make the order today, it's 21 days to transfer or 21 days to rule on it.
If no controverting affidavit, it's a mandatory transfer that was filed on Monday, I believe, or Tuesday. I was on vacation on Tuesday. So 21 days from Tuesday. Your rulings have been very clear, and I don't expect that we need to have it, but in the event that we do, I just wanted to make sure the court still had plenary power.
All right, so that was and I'm sorry, what was the middle day, Ms. Riley, the 12th?
Yes, sir, May 12th.
All right, so we'll set it on May 12th. That's only if y'all are unable to get it reduced to writing by then.
Your Honor, I will be out of the state on May the 12th. That's why I said May the 18th.
Okay. All
But
right.
I believe that if you are ordering the mandatory transfer, you've already orally pronounced it, so she's covered. And we're not disagreeing to it. The child has lived in Guadalupe County for more than 6 months, so there will be no controverting affidavit.
But
All right.
it has
I understand that if it's been transferred, then
this was all for nothing.
No, the only thing that the transfer is I would have to file a controverting affidavit. If I don't, then she automatically gets it transferred, but she would have to come to you to get that order. So as long as this order is signed first and then the motion to the order to transfer is filed after it, that's fine.
all right. So I'll set it for the 18th. I'll sign both of them on that date.
Okay.
Thank you.
Thank you.
May we be excused?
Yes.
Thank you, Your
And
Honor.
we're going to take a brief break, Mr. Cedillos, and then we'll come back. Is that your client?
Yes, it is.
Okay, well, let's take a break until 1:30. That's about 7 or 8 minutes, and then we'll take up that. I'll be right back.
All right. Okay, thank you, Honor.
All right, Mr. Cedios. Let me grab that file.
Okay.
212110. All right, Mr. Cedios, and your clients are Alexander and Alexis Jefferson?
Yes, Your Honor. They're the parents, yes.
Okay. All right, and is Mr. Jefferson an adoptive parent or?
No, no, Your Honor. They're natural parents.
Okay.
The Alexander and Alexis, his wife, they changed their names when they became U.S. citizens. Is that correct, Mr. Jefferson?
Yes.
Yes,
Okay.
they changed their names to Jefferson
Okay.
when they
All right.
they became U.S. citizens.
All right, that's fine. Okay. All right, do you have your proposed order?
I do, Your Honor. We submitted it to the district clerk this morning.
It is in the e-file, Judge. I can forward it to you if you'd like.
If you could just post it in chat, or actually, let me see if I can get on the e-file again. I thought I had Wilson County knocked out. I guess they came back and filed new things.
I know I filed something.
Yes, if you would send that to me, it may be at the coordinator. There's nothing in my Wilson County queue.
You can get in there real quick if you need me to, Judge.
Well, I had it pending. I can send it right now to the coordinator, or I can do it in chat.
The chat would be faster. Oh, actually, Mr. Cedios, you posted something at 1:13.
Yes, that's their citizenship, where they
Okay.
became naturalized citizens.
Okay.
Judge, what happened about 3 weeks ago, this matter was set before Judge Ellison, and he was a little bit concerned because they were foreign nationals. He didn't know he had jurisdiction, but I did a little bit of research, and under the immigration code, they are U.S. citizens. And I'm sure the court is familiar with having adopted a child from another country.
Okay, and well, I don't know that. So were they born in the United States or?
2 of them were born in Iran, is that correct? Iraq, I'm sorry, my bad. But one of them was born in San Antonio.
Okay, all right, that's fine.
And the petition is verified, Your Honor.
Yes. No, it all appears, okay. All right, I will post this to Ms. Tejada right now.
Okay.
My mother's an immigrant and I was born before she was naturalized, but I'm a US citizen. Okay, I mean, I'll let her open that up and make sure she gets it. Sometimes they get corrupted when they go through.
Got it, Judge, and was able to open it.
Okay, all right. And are you gonna, okay, I wish y'all good luck with that. Have a good day, sir. You too, Mr. Dios.
Thank you, Your Honor.
Okay, y'all wanna go over the dockets?
Yes, please.
Not really, no? All right, let me open up, what am I missing?
I think I got everything, but yes.
Okay. Current civil transfer to Wilson County. I signed that, so that's been done. At Escosa Civil, SEMA Resources, I signed a partial judgment because it doesn't dispose of all the errors, and they're going to get that, something severing that out to me. Rendon, reset on request. Julian Ibarra is now pro se, and Eki is the attorney only for
Rendon.
Rendon.
Okay.
Okay. Mendez, reset on request. Actually, her husband, I figured out, had signed off on that, but there's still the other child, so we couldn't have done that today. Final judgment in the 2 expunctions. Wilson County, Leal, reset on request. Mendez, 5-5. Marriage of Riley, remain on docket.
Is there an
James
order
Riley-
granted on that one, Judge? I had, of temporary order was a,
No, it was just a withdrawal. No, there were two Gonzalez, I think he needs to get me the order allowing him to withdraw. I'm not sure I signed that, but I signed a motion to compel and a motion to clarify.
okay, that withdrawal is set, I think, next week for.
Oh, okay, okay. That's
Actually.
why I didn't sign it. All right.
And I think they did post some orders in the chat on those.
Yes,
compel.
I signed those two. I signed those.
All right, good.
To them. All right, Palashik, 510. Foster, 518 entry.
Oh, that was, is Foster reset for entry as well? I didn't have that.
Wait, no, Carson Foster.
I just have temporary order granted on that one.
Okay, you're right. Do we have an entry date? We talked about one. Do we know?
No, they didn't ask for one, but they can get a hold of me if they need to.
Temporary
I think they were
orders
trying to work it out.
to be filed. Because we haven't done
Okay.
it. And on the Yahweh children, final judgment.
Okay. And then the Brighton case is the one that's reset
Yeah, add-ons, yeah, 518.
for entry.
And whenever we get that set, it'll be transferred to Guadalupe.
Okay.
All right.
All right, good deal.
Okay, anything else?
No, and you haven't heard any word on your new computer? I think Jennifer was gonna check into it for you. I don't know if what she's found out yet from Justin, but
I saw her, she emailed Justin and asked me what's going on. It was delivered yesterday.
oh, okay.
All right, goods, because I want to get him to set up on my old and now current personal laptop. The only people I can get into are Wilson County. Frio,
Okay.
Carnes, and LaSalle weren't on it before it became my backup. And at Escosa, I can't view the documents. So I'm going to get him to set all that up. Hopefully we
Yeah,
can-
and if Justin's not available, Craig is very helpful as well.
Okay, okay, all
Craig
right.
Smith.
Well, I guess that's it. I will see y'all soon.
All right, y'all take care.
Now, this doesn't look too bad. How washed out white do I look most of the time?
I don't
And
notice
this new
anything.
camera is funky, or the camera on this computer is funky.
It looks like there's a globe shining down in your head though. It's real light on top.
Yeah, that's the baldness coming up. But yes, I had the overhead lights on.
Yeah, there's a light on you.
But it's either dark and then the light from the monitor next to me shines on and makes half of my face wash out.
Sometimes you fade out when you're flipping your arms. It's like you're a ghost, like you're invisible man, maybe.
It's just, okay. Oh, it's not just
It's
me.
your halo.
It's your, yes, it's halo. Yeah, that's it.
Or,
Or the horns, I don't know.
all right, I'll see you all in the morning. Bye-bye.
Okay, all right, bye. Bye, Lachey.